Yes.
May I please, Your Lordship, my lord?
Yes,
Lord,
you may.
I have a prayer in item 8, my lord. This is a part heard matter of court number 9, my lord. It may kindly be, my lord, distributed.
Item number?
8, my lord.
Item number 8.
It's a part heard matter of court.
All right. You are Mr. Zaid Hamid.
Yes, my lord.
As prayed for by Mr. Zaid Hamid, learned counsel appearing for the petitioner, relist before the appropriate bench, as it is stated that the matter is part heard by another bench.
I'm deeply blessed.
May please, Lordship. May please, Lordship. I beg to mention item number 2, Lordship. Item number 3, Lordship. And yes, for today, Lordship.
Why?
Lordship, today I have some difficulty, Lordship.
You are Mr. Hussain.
Yes, Lord.
As prayed for by, it's a 2017 matter.
Yes, Lord.
You wait for your turn. Yes.
My lord, item number 21, my lord. It's also a whole matter. The matter is pending before the Honorable Supreme Court, my lord. There is second round litigation. If that matter is decided by the Honorable Supreme Court, this will have a bearing on this present matter as well, my lord. And a similar prayer was made on 7/11/2024 when the matter was last taken up. So if your lordship kindly adjourns the matter.
Mr. Sharma, you wait for your turn.
My lord.
Let me have a look at the file
My
because these are old matters.
My lord, sure.
If the matter cannot be proceeded because the matter is sub judice before the apex court, certainly this court will wait for some more time. But let us first just have a look at the last order. During mentioning us, it's very difficult to see the files. All right.
Before mention item number 14, Lordship.
Yes, what do you want?
Password for a day, Lordship.
14.
Yes,
Where you are for the petitioner? What is the difficulty?
Arguing counsel is in embarrassment.
Mr. Kaushik.
No, Lordship, SRG.
Yes? But there are many legal counsels otherwise. Anyway, as prayed for by MS, so and so learned counsel on the ground that the arguing counsel, Mr. S. Hajorika, is in bereavement, relist on such and such date. Yes, next.
Can the matter be released on 26th?
I've already said you take the date from the court.
There is an interim.
Interim, if any, shall continue to the next date of listing. Yes, next.
Wait, please, Your Lordship. With the consent of the other party, I beg to mention item number 28.
28.
We will be filing our affidavit during the course of the day, so kindly adjourn.
Okay.
Also seek for a short accommodation on the 26th of February.
All right.
Subject to the conditions of the
You are for whom?
And for the respondent.
From the
I'm for the
respondent.
petitioner, Lord.
You are for the petitioner. MS?
L. Izum.
MSL Izumi.
Izum.
Izum. Learned counsel appearing for the respondent corporation
Yes.
submits that an affidavit of opposition shall be filed within the course of the day and accordingly
Additional.
additional within the course of the day and accordingly seeks a short accommodation. Prayer is not opposed by Mr. S.P. Roy.
J. Das.
Mr. J. Das, learned counsel for the petitioner. Relist on such and such date. Short date. Yeah. And next.
May please, Your Lordship. Lordship, I would like to mention item 20. With due consent of the government leader, I would.
It's a 2016 matter.
Yes, sir.
Wait for your turn. Yes, next.
May please, Your Lordship. I beg to mention item number 16 and 17, Lordship.
Yes.
Due to some personal difficulties, Lordship, and then Khatuni has not come today. Matter may possible for the day, Lordship.
All right. Your name?
P. Sutia.
MSS Chutia, learned counsel appearing for the review petitioner seeks a short accommodation on the ground of personal difficulty of the arguing counsel, Mr. N.J. Khatonia. Prayer is not opposed. Relist on such and such date. Yes, please call the list.
Item 1.
What is this, Mr. Chaudhary?
Yes, may it please the Lordship. Lord, the petitioner before Lordships, they are presently working as Forester Grade 1. Lord, their grievance is they were promoted to the next grade of Lord Deputy Forest Ranger. But subsequently, Lord, that order was Lord cancelled. Similar exercise was undertaken in respect of Forester to Forester Grade 1. By the same impune order, the promotions were cancelled. But, my lord, the promotion was, their promotion was restored, but our has not. That is how we are, my lord. And there is a misinterpretation of the provisions of the rules. The cancellation order I'll place, my lord, wherefrom it will be clearly evident.
You are the applicant.
I'm the petitioner.
No, but this has come for stay vacating.
Miller,
Who has filed the stay vacating?
Miller, I have filed a Miller. This was filed by the private respondent, Miller. They are also entitled for promotion, Miller. So their claim is that.
So right now, I find what is listed before
On last
this.
occasion, my lord, the understanding was instead of taking up the IA, my lord, whole matter will be taken up. It's a very short matter, my lord.
My lord,
No, the order of 28/126 says the considering the above, list these matters again on so and so in the stay vacating column.
my lord, in the meanwhile, what happened, my lord? Now already department has initiated the selection procedure for promotion from Forester 1 to Deputy Ranger, my lord. Now already promotion has been granted and some of the petitioner, applicant, my lord, already, my lord, granted promotion now. Now yesterday I have already filed an additional affidavit, my lord, in the writ petition, my lord, second writ petition which is filed by me, my lord. So, my lord, that is not in record. So, lord,
No, my lord, that's a different aspect. This subject matter remains the same. My lord, you kindly.
Mr. Chaudhary,
Yes.
if he has filed an additional affidavit and the order of 28/1 says, list these matters in the stay vacating column, indicating perhaps that all the matters can be decided together, which
No,
also
my
you
lord,
have fairly
the
said.
idea of
So in
getting
that
to-
case, I think that additional affidavit has to be brought on record. You have it on Thursday then.
My lord, additional affidavit will only show who all are.
We don't know, Mr. Chaudhary, he has filed it. It's not on record today. So we'll have it on Thursday or next Monday.
Thursday,
Ah.
Thursday.
Let it be Monday next minute.
All right.
My lord, for disposal, my lord.
Yes, I'll indicate that. Heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. R. M. Dekal, Learned Counsel for the petitioner. Also heard Mr.
Case in, my lord.
A.
K.
K. Singhal, Learned Counsel, appearing for the caveator respondent. The interlocutory application seeking stay vacating is also is listed before this court today, along with the writ petitions. Mr. Sinha submits that an additional affidavit has been filed yesterday. Yesterday, however, the same appears not to be placed on record. Let registry verify and place the same on record. Relist on Monday so and so. Since the pleadings are stated to be completed and an endeavor to dispose of the entire matter at this stage shall be made. The matter is otherwise I admit it.
Notice.
So at the admission stage, I will
Admission.
indicate.
Admission.
Admission stage.
Diploma.
So old matter, where is Mr. Hussain? Yes.
Yes. This senior will argue this case, Lordship. He is out of station, Lordship.
So you are there
Yes, Lordship. So next week, Lordship.
on 20th January 2026 also you made a very similar
Yes, sir.
submission before this court.
Lordship.
This is a 2017 matter. Please show some responsibility. You are an officer of the court. Should I read out the last order of January 2026?
Lordship,
Mr. M. Hussain, Learned Counsel for the petitioner, submits that Mr. B. Sinha, Learned Counsel, will argue the matter, and since he has some personal difficulty today, he prays that the matter be listed after 2 weeks, and accordingly the matter was listed today, that is 17/2/2026. This date was fixed.
Lordship.
Yes? You argue?
Lordship, then fixed at 2, Lordship.
This court had already given a fixed date. Despite that, you are making the same prayer before this court.
Lordship.
Please be mindful. It's a 2017 matter.
Yes, Lordship. Lordship.
This is not the way the officers of the court. Yes.
Lordship. Actually, B. Sinha will, Lordship, he has some difficulty, Lordship. He had can't, his native village, Lordship, Haflong, Lordship. So,
I'm going to post it on Friday. You make arrangement and deposit cost. Otherwise, this matter gets dismissed for default.
then at 2, Lordship, I will argue, Lordship.
Very well.
At 2, Lordship.
With that matter. Yes.
Item 4.
Pension.
Yes, Lordship, pension. This is the last order, Lordship, 28/1/2026 is there, Your Lordship.
Yes.
28/1/2026, Your Lordship. There's an order.
Yes, I'm seeing it.
Yes.
What do you want to point out from here?
No, this Lordship, this case is already covered case, Your Lordship. I have filed an affidavit in reply. There's an in this affidavit in reply, Your Lordship, I have shown.
One second. You want me to have a look at the order of this court passed on 28 January 26?
Lordship, this is what.
One second. Let me just read it. So 31 years of service. If we adopt the principle laid down in Saribun
Saribun.
Nisa and Fazle Rabi.
Lordship.
Yes, Mr. Datta?
No, my lord. Our stand is that it's not covered under those cases, my lord. In fact, this case is covered a different case, my lord. All Assam Gaon Panchayat Secretary Association case, my lord. So he may proceed, my lord. I have submitted one written argument also, my lord. Taking all the points, my lord. May I submit a difference, my lord, of both the cases?
One second.
My lord.
So according, first of all, what is the basic facts of the case? One of you can just simply sum it up, please.
Lordship. Initially, Lordship, I have been engaged as a fixed pay employee, Your Lordship, under as a teacher, Your Lordship, under the PNR department, Your Lordship. So at that time, Your Lordship, some schools were run by them. Subsequently, Your Lordship, I have been engaged. This schools has been abolished. We have been engaged as a tax collector under the block development of the Lordship. This takes, Your Lordship, after initial appointment of 8/2/1982 to 99, Lordship,
Yes.
I have been working as a fixed pay. Subsequently, Your Lordship, under Assam Panchayat employees, Your Lordship, provincialization.
Have you received the copy of the written arguments given?
Just now I have received.
You have given. So
Just-
you have a look at it. I'll post it, and if you want, you can file your written arguments. We can have it on next Tuesday. But we will dispose it of next Tuesday.
Lordship.
Huh? Heard, Mr.
Ice Borvia.
I.H. Barbuya, Learned Counsel, appearing for the petitioner. Also heard Mr. S. Datta, Learned Counsel, appearing for the respondent. PNRD department. Huh? Pursuant to the, and Mr. Talukdar, R.K. Talukdar, for respondent number 5. Pursuant to the order dated 28/1/2026, Mr. Datta submits a written submission on behalf of the PNRD department to content that the decision rendered by the coordinate bench of this court in the case of Saribun Nessa Majumdar versus State of Assam, dated 11/11/2024 in so and so, as well as the learned division bench of this court in the case of State of Assam, so and so, is not applicable in the context of the facts and circumstances of the present case. Mr. So and so, learned counsel of the petitioner, seeks a short accommodation to go through the written submission and respond thereof. the petitioner are at liberty to file any written synopsis in, if so advised. Relist on such and such date.
I'm submitting this judgment will cover this case.
As Dr. Taragote Koidya, Mr. Datta further submits that this is a coordinate bench.
Yes.
That the that the decision of the coordinate bench rendered in the case of so and so versus so and so in WPC 4506 2018 on the contrary shall be applicable to the facts and circumstances of the present case. You have a look at it.
Monday, your lordship.
Monday দিব পাৰে? Okay, Monday. Itu মোক point out কৰি দিবা ফাইলটো।
Highly applicable.
Item number 5.
Yes.
The matter is wrongly listed in the admission column, lordships. On the last occasion, the matter was admitted and was fixed for hearing, lordships. Who have paid it, the matter may be taken up next date anyway.
Mr. Sharma,
The person has retired long back. Lordship may fix it on Thursday for hearing column.
Thursday আমি পাৰিম। Okay. Mr. DK Sharma and Mr. A. Dhanukara,
That's it.
learned counsel for the respondents. What is the matter? It is for reduction of basic pay by
Yes,
2
yes,
stages.
yes.
The matter otherwise is simple.
Matter otherwise.
All right. It is submitted at the BAD. The matter has been wrongly listed in the admission column and seeks posting the matter in the hearing column on, when do you want it? On Thursday, I so and so. Prayer is allowed. A relist under the appropriate column on such and such date.
Item 6.
Yes, Mr. Mohanto.
My lord, this is regarding the withdrawal of advance in.
Yes, Mr. Upamanyu, some instructions you had taken time.
Lordship, yes, Lordship, that instruction is still awaited. Lordship.
Why?
Lordship has not received it in writing, but Lordship, telephonic instruction is that this is not applicable at the current moment, Lordship. This page 67, Lordship, which
Page?
67, which the finance department have brought on record by way of an affidavit. This OM, Lordship.
Is not applicable.
Yes.
This is your
Yes,
but I think then you'll have to
yes, Lordship.
file it.
Yes, Lordship, I'll have to opt in.
He will have to need a time to respond, isn't it? The OM at page 67, annexure A.
Yes, Lordship. To which they have no objection for modification, Lordship. That OM, Lordship.
Heard Mr. P. Mohanto, learned counsel appearing for the petitioner. Also heard Mr. D. Upamanyu, learned standing counsel, Higher Education Department. Mr. D. Upamanyu submits that though the written instructions are still awaiting, however, it is learnt telephonically that the office, it is not an office memorandum, page 67.
This is an communication from the finance department.
That the
Yes,
that the views of the finance department as available as annexure A to the
affidavit filed by the finance department.
affidavit in opposition filed by the finance department is not applicable.
yes, sir.
Is not applicable in the facts and in the facts and circumstances of the present case. He seeks a short accommodation to complete the instruction by way of affidavit. Prayer is not opposed by Mr. So and so. Relist on such and such date.
The one date may be fixed. My lord. The long pending case. My lord. 17.
Highly obliged.
No, my lord, that can be preponed on 16.
Yes, we can, I'm sure.
Obliged, actually.
Item 7.
Pension.
Affidavit not filed.
Why pension matter? Affidavit still not filed? This matter is going on since 2021.
Lots of, my instruction is that the provisional pension has already been paid.
All other benefits are done.
All other DCRJ and all was pending because of a pendency of a GR case against the petition.
GR case, he has been
And on the
acquitted.
last occasion, my learned friend submitted that GR case.
He has been acquitted.
Then what is the hurdle?
So pendency of the GR case was the.
No, now how much more time you need? You can clear it that has been already acquitted.
If he has been already acquitted, let
Here it is there. In fact, on the last occasion also, the submission was made, which is recorded in the judicial order of this court. By now, you should have taken your instructions.
Lordship, perhaps that order has not been submitted, so that might let the petitioner punish the order before.
Then I will dispose it off.
Lordship, in that
Why should we keep this matter pending? He's already been acquitted. The order is given here because that is the only hurdle according to you.
Lordship,
I'm disposing it off.
Fine.
Heard, Mr.
Yes,
Esnath, learned counsel appearing for the petitioner. Also heard, Mr.
P.N. Sharma.
P.N. Sharma, learned counsel appearing for the learned standing counsel.
Lordship.
Elementary Education Department. Stop. By way of this instant petition under Article 226 of the Constitution of India, the petitioner is seeking inter alia release of the retired benefits of the petitioner, i.e. provident fund, money, gratuity, GIS, leave encashment, regular monthly pension, etc., with effect from the date of his retirement on 31/10/2009 with interest at 12% per annum. The brief facts of the case is that the petitioner retired on 31/10/2009 on superannuation from the post of the head assistant of the office of the Deputy Inspector of Schools, Hailakandi. He is aggrieved with non-release of provident fund money, gratuity, GIS money, leave encashment, provisional regular pension, etc. It is the specific case of the petitioner that with the impugned letter dated 16/11/2021, whereby he was show caused under Rule 9 of the Assam Services Disciplinary and Appeal Rules 1964 as to why any of the penalties prescribed in Rule 7 of the aforesaid rule should not be inflicted on the petitioner on the charges based on statement of allegation. His retirement benefits have been stopped. He has been thereafter, he has been placed on suspension on 21/10/2009. However, he retired on 31/10/2009, and after his retirement, he submitted pension papers via letter dated 25/6/2010 to the Deputy Inspector of Schools, Hailakandi, for sanction of provisional pension and DCRG. However, till date, since the same has not been released and paid to the petitioner, the present writ petition was necessitated. Mr. So-and-so learned counsel for the petitioner submits that the provisional pension has been received in the meantime. However, the other retirement benefits are still not paid to the petitioner. Mr. So-and-so learned standing counsel submits that since there is a GR case pending against the petitioner, the final pension could not be given to him and that he is otherwise enjoying provisional pension.
And there is a departmental proceeding also pending. Yes, page number 36.
And a departmental proceeding is also pending thereof. No, but I'm disposing it off today.
Lordship, by bringing this departmental proceeding into a logical conclusion.
No, but how can I give that finding here?
Yeah.
That finding is not
no
here.
affidavit or inspection.
You have not filed that.
That-
So I'm not going into the department. Your main submission was that I'm taking note of that only.
Lordship.
It appears that the petitioner has already been acquitted in the GR case number 6976 of 2009 by the Court of Civil Judge Junior Division number 1 cum Judicial Magistrate First Class District Hailakandi by judgment and order dated 31/7/2025. A copy of the aforesaid judgment is furnished before this court, which is taken on record. What is that?
This is an instruction. Why that?
Sound? You see, when I asked for whether I can dispose it off on that, you immediately agreed. Now, don't make things difficult.
Paragraph. Second paragraph. Same thing. Lord.
I think this is clear.
Lordship.
It further appears that the a perusal of the instruction dated 4/11/2023 received by the Standing Council, a copy of which has been furnished before this court and placed on record and marked as A, B kori diba etu, agor to A koriba, etu B kori diba, indicates as under, quote unquote, 1 and 2 to kori diba. It appears that the only hurdle for non-release of the pensionary benefits to the petitioner was due to the pendency of the criminal case. Since the petitioner has already been acquitted in the criminal case, there appears no hurdle for release of the pensionary benefits to the petitioner. In fact, Mr. So-and-so, Learned Standing Council, fairly submits that since he has been acquitted, perhaps the pensionary benefits can be released in accordance with law. Considering the aforesaid endorsement made by the Learned Council for Standing Council, and upon perusal of the instruction received by him, including the judgment of the criminal court, this court, in the interest of justice, disposes of the writ petition by directing the respondent authorities to release the retired benefits of the petitioner. I think balance, no?
Balance, only provisional regular pension, balance and GI at every retail benefit, as Lordship mentioned in order.
Retired benefits including
Including
regular pension,
regular pension, provident fund, gratuity, GIS money, leave encashment, provisional regular pension, etc. Nothing else.
in accordance with law, within a period of 1 month,
Take some time, Lordship, because
2 months.
Two.
2 months from the date of receipt of the certified copy of the order.
Yes. Okay.
Item 9.
Just 1 second, Councillor Matakul. Na lage, ho. This there is a stay order mentioned here. There was some stay order here.
For release, my lord, of
Huh?
provisional pension.
there was an instruction to release the provisional pension.
On the first day.
Oh, that is why. Okay.
First-
So that was the why it is mentioned.
On
All right.
strength,
All right.
strength of that order is getting the.
Okay. Understood.
Item
Yes. Mr. Goswami, where is your counterpart?
Flying clubs, Lordship.
Hmm?
Flying club. One
Flying club.
Yes, Lordship. It's a club affiliated.
Anyway, is not there. None appears for the petitioner on call. Heard Mr. Goswami, Learned Additional Senior Government Counsel, and Mr. MS. So and so, Learned Counsel appearing for the respondent. Give your appearance slip. Give your appearance slip. List this matter under the column for dismissal on Friday.
Item 10.
Order tanike mari diba moja tamaru decide format. Yes.
My lord, this matter relates to relaxation of age in respect of the petitioner's appointment, my lord, in college. In the earlier occasion, Lordship, my lord, the petitioner approached before Lordship for a consideration of age be relaxed, and Lordship has given a direction that to approach the authority for appropriate prayer. So accordingly, my lord, I was allowed to participate, and I was by relaxing the age, that was I allowed to open appointment in join in the college. And after doing certain months, I was immediately so it was issued that as the relaxation was not by the proper authority, so cause was issued to me there to so cause on that day because the relaxation was not by as per rules. So why your service should be terminated? Accordingly, after filing of my representation, they were not satisfied, and accordingly I was terminated. Then I filed another writ petition. In during this time, my lord, the Lordship, my lord, being satisfied, the grounds that they say there is no provisions of any relaxation of the OM and other things. The court said that produce, you say they, whenever there is no such notification, you file a affidavit to that effect. But they fail to file any that type of effect to that effect. And ultimately court says to produce that OM because they have specifically mentioned the OM of 51. So now, during the time of the, my lord, this pendency of the case, the similarly situated, my lord, persons, one of them, my lord, I approached before lordship, they were, my lord, appointed. They were also advertised, my lord, the same Bodo post newly created in some 5 colleges. Total 9 posts were created. One of the posts was given to Tekazuli, my lord, Allocati College, where I am working. So my prayer is, my lord, that they also agreed that on that basis, that petition may be disposed of. So I will file a representation, and in the light of this already been appointed, my representation will be considered.
No, but in this present repetition, that is 751, your
Yes.
challenge is your termination.
Termination, my lord. The only ground that I was overaged. I was otherwise my.
And on the last occasion, Mr. Uppavani, you had been directed to produce the relevant notification
Yes.
as regards age condonation.
Yes.
So do you have any notification?
Lordship, there is a notification at Lordship, even in page 86 of my affidavit in opposition at para 11, Lordship, I have referred to that notification. Lordship.
But they failed to produce the notification.
Yes. Page 86, yes.
Yes, Lordship.
Para 11.
Yes, Lordship. Yes, Lordship. May I read, Lordship?
Yes, please.
Lordship, that as regards to the statements made in paragraph number 19 of the writ petition, the deponent begs to state that the notification number AP 3450/2027 dated 3/5/1951 issued by the Personnel B Department Government of Assam provided as general rules for relaxation of age limits. Point number 4. In pursuance to the provisions of Article 309 of the Constitution of India, the Governor of Assam is pleased to make the following general rules regarding relaxation of the age limit for recruitment of civil service for civil post in connection with affairs of the state of Assam. Number 1, notwithstanding anything to the contrary in the rules regulating the maximum or minimum age of recruitment to a service or post in connection with the affairs of the state of Assam, the age limit may be relaxed in favor of any candidate or class of candidates only if, number 1, in case in which appointing authority is the governor, or number 2, in other cases, the head of department considers this necessary in the interest of fair dealing or in the public interest. Number 2, in this rule, head of department means the authority who is declared to be the head of the department for the purpose of the fundamental rules and of the subsidiary. And
So what do you mean? In the case of the petitioner, the age can be condoned?
yes, Lordship,
This
but-
is your
yes,
stand, isn't it?
Yes, Lordship.
Yes.
But Lordship, it was never condoned, Lordship, and his appointment was issued due to oversight, Lordship. That has also been stated, Lordship, in the affidavit, Lordship.
No, but now what is before this court is the termination.
Yes, Lordship. So he wants to file a representation stating that other similarly situated person have been, their age has been condoned and they have been given appointment, Lordship. To that, Lordship, I do not have any objection, Lordship. It is the department, they will decide, Lordship, they can file a representation before the department, Lordship, stating that other candidates were also appointed.
The termination was on the ground that his age was
Never
not condoned
condoned, never
and he was overaged at the
Yes,
time
Lord.
of appointment.
Yes, Lord.
So there appears no illegality in the termination order because
Otherwise, they say
age
that
condonation is a discretion. It has
discretion,
to
but
be
they-
applied.
But they say that there is no such OM. So court had, my lord, pointed out this thing, is there no
What
OM.
no OM?
OM
It
is
is there.
51, OM. You had referred my.
The
my lord,
OM for condonation.
condemnation.
See, whether the OM is existing or not existing, in either case, you are overaged.
No, that is true, my lord, but.
So when you are overaged, where do you have any, the question whether the OM is in existence or not is also of no relevance.
No, my lord,
Because if I've understood you correctly, Mr. Mohanta, that you have been terminated on the ground that at the time of appointment, you were overaged. Correct?
this is true.
Is that correct?
Yes.
Lord. And
So
he's-
if that is correct, end of the matter.
No,
Whether the OM exists or OM doesn't exist is of no consequence.
No, my
A-
lord,
And you see, they don't need any order from this court to exercise the discretion.
my
It
lord,
is for the authorities.
my
I don't see any case,
lord, my
Mr. Mohanta.
my lord, one facts, my lord, behind it, this is, my lord. The petitioners, he was working since 2004. That was a non-sanctioned post in the college because there was no such post, Boduk post was created in the colleges. Subsequently, my lord, on the pressure of certain political lies and other things, a certain Bodu posts were created and that will be allotted to particular colleges. So accordingly, in 2 posts were allotted in my college. One, my lord, this is senior to me, he was adjusted against that post. And the second one, my lord, for that, my lord, they said that you go for a selection process. So in that selection process, my lord, as I was, my lord,
Overaged.
so I was not otherwise eligible to participate. So I approached before the court, that on the reference of that 51, court allowed that you file a representation and you may be allowed to participate in this election.
But that 51 may not be existing.
Now
only.
that is still existing, my lord. Kindly see, my lord, one of them I have annexed, my lord, the appointment,
Where is that order where the court had given you liberty to?
yes, my lord.
Where is that order?
Lordship will come to page 41, my lord. It's a long order.
My lord, 4 sorry, number.
My lord, the lordship will come to.
Making to dispose Korean.
My lord, lordship will come at page
To me,
45.
to disposal page 45.
Paragraph 5. That the Learned Standing Council for the Higher Education Department has submitted that the notification dated 3/5/2019-51 for relaxation of age when in force, which provided the age relaxation. The same is found affirmed from the decision rendered by the court in the case of Begum Akhtar Supra. It may be mentioned that in case of the Suparna Hazarika Supra, the
Anyway, where is the operating part? Operating part.
Operating part, my lord, coming.
This is in respect to you, isn't
Yes,
it?
my lord. Yes, my lord.
The same petitioner.
This is my lord, page number 47. Para number 9.
Yes.
The principal Lokonak Omniacon class Vikadili is directed to receive the application submitted by the petitioner, namely Khonidhar Basumatari, as a candidate for the filing of the post of the assistant
Okay.
professor.
After this, what happened, Mr. Mahanta?
After that, my lord, I have filed a representation.
Where is that?
My
I'm just indicating, I am flagging,
madam.
because you see, I'll have to authorize the judgment. So I am
Yes,
trying to take
Yes,
from
madam.
the pages.
Page 50.
Page?
50.
Page 50. This is your
Yes,
representation.
my lord.
Then,
My lord, I was allowed to participate, and on recommendation, my lord, this is lordship will come at page 52.
yes. You're appointed as assistant professor.
Yes, my lord.
Correct?
Yes,
Now, this was terminated by the
after
impugned
4
order.
months, my lord, that is come to the notice that she is not
Wait,
up.
Wait. Page.
Yes, madam. 59, madam.
After 4 months.
Yes, madam.
After 8 months.
And this is what is challenged.
Yes, sir.
Yes, no.
After
8 months.
8 months.
8 months.
The last
Now that similar order that you want to show something more?
yes, madam. The lordship, my lord, in similar circumstances, I approached before the lordship.
Yes,
In
that
the
is what
similar-
I wanted to
Yes, my lord. In page number, continuous page 78 and 79, my lord.
70,
8 and 79.
78 is some order. Dipali Kharkatari. I think a similar person.
See that, and we have been condoning the age, and they were.
No, but where are the orders of this court? You said there are some similar orders of this court.
This is not I am an expert. The Dipali Kharkata, I was the petitioner, my lord, so I am aware of these things, my lord.
So didn't you say that there has been an order of this court to
In those writ petitions, lordship, their age has been condoned, lordship, and then
which are those series? One is 79 and
One is 70.
78, 79. How many are there?
This is 2, my lord.
2, and the averments to this annexures are in which page?
It is, my lord, the 79. It is annexure 8 and 18.
No. In support of the annexures, where do you find the averments in the affidavit?
Yes, my lord. This is, yes, my lord. In para lordship, 14, my lord.
Para
14.
14.
14 of these, this is 75 page number.
Okay. All right. So taking note of your stand in the affidavit that that power is there, relating it back to the judgment by which that liberty was given, pursuant to which he had filed his application, I'll dispose it of.
But lordship, here in this case, his age was never condoned, lordship.
That
And he
is the
was-
issue, my lord.
That is the,
No, but
Yeah.
in respect of these two people,
It
they
is
have
a
been
condone
condoned
and
later.
appoint-
yes, lord.
So what should be the operating part of the direction?
Well, my age should be condemned accordingly in consideration.
No,
of
no,
the
I
light
am not giving any positive direction for age condonation.
But in the light of this, my lord, the appointment is similarly
uh,
circumstances. my lord.
By
Right?
taking
They may
note of the,
consider-
Yes.
They may consider.
by taking note of the fact that similarly situated
Yes,
persons,
yes.
they have done it. So in the event, I'll give a liberty for them to reapproach with these additional papers.
Yes, ma'am.
And in that situation, within a fixed time,
Yes, ma'am.
you may take a fresh call in the matter.
Yes.
Okay? Heard Mr. P. Mohanta, Learned Counsel, appearing for the petitioner. Also heard Mr. D. Upamanyu, Learned Counsel, appearing for the respondent, Higher Education Department. Mr. S. Upadhyay, Learned
Principal and governing.
Counsel, appearing for respondent numbers 3 and 4.
Lordship, I am for 1 and 2.
MS D. Bora, D. Bormon, na? Learned Counsel, your additional senior government advocate for the state of Assam for respondent number 5. Correct? Do you all want to say anything? By way of the instant petition under Article 226 of the Constitution of India, the petitioner is assailing inter alia the impugned order dated
Annexure 16 at page 59.
dated 30/12/2022, whereby the appointment order of the petitioner dated 23/9/2022 as assistant professor in the Department of Bodo of LOKD College has been cancelled and withdrawn. Stop. On the ground that the petitioner was overreached at the date of appointment. Correct?
My lord.
Stop. The brief facts of the case is that the petitioner is working as a lecturer in the Department of Borough Non-Sanction in LOKD College. Pursuant to an advertisement issued by the respondent number 3 for filling up of one vacancy against the post of assistant professor in the college on 23/3/2022 in the Borough language, the petitioner though wanted to appear, however, was barred as he was barred under the terms and condition of the advertisement, as he had already crossed the maximum limit of 45 years for which the college did not accept his application for the said post. Accordingly, the petitioner preferred a writ petition, which was registered and numbered as WPC number 2346 of 2022 before this court, and this court wide judgment and order dated 1/4/2022 was pleased to dispose of the said petition by directing the respondents to accept the petitioner's application directed the to receive the application submitted by the petitioner for the said post upon and upon the petitioner making a prayer for condoning his age, his his age, and or for relaxing the upper age limit for the said post, the respondent authorities shall consider the same. Just 1 second, Mr. Mohanta. At page 48, is this what is the direction? The direction is to condone or direction is to consider?
Consider.
Consider.
It is directly. that
He
can
was
be-
given liberty to file a representation for confirmation.
He लिखेला last up, and upon such an application, the respondent authorities and the respondent authority. Take it. Son is it. Accordingly, the petitioner filed representation on what is the date of a representation?
My lord, this is
Page 50. I don't
Yes.
see a date.
Yes, my lord.
Filed a representation before the respondent authorities. Seeking condonation of the age of the petitioner for enabling him to sit in the interview pursuant to the order of this court. However, now thereafter he was appointed, no?
Yes, ma'am.
Thereafter, the
On recommendation of.
the petitioner, thereafter, accordingly, the petitioner was allowed to sit, right?
Yes, ma'am.
He was allowed to participate in the selection process, and upon being selected, he was appointed as assistant professor by order dated 23/9/2022. However, after almost a lapse of 8 months, by an purported speaking order, by a speaking order dated 30/12/2022, the respondent authorities refused to condone the age of the petitioner for the subject post, and accordingly cancelled the appointment order dated 23/9/2022 by the said impugned speaking order. Aggrieved by the aforesaid, the present writ petition has been filed. Mr. Mohanton, learned counsel for the petitioner, submits that that similarly situated persons who had also submitted similar applications for condonation of their age for the subject post were considered by the by the respondent authorities by applying the office memorandum dated
This is my lord.
by where do I find the reference? It is there.
Yes, my lord. Yes. This is my lord 3/5/1951.
3/5/1951.
51. Yes.
He further submits that on the other, Mr. V. Upamanyu fairly submits from the records that the OM dated 3/5/1951 empowers the state respondents to condone the age limit granted under the terms and condition of the advertisement for the subject advertised post in accordance with the discretion prescribed under the said office memorandum. Correct? So, heard peruse kore diba. Apt at the outset to refer to the order of this court passed in WPC 2346 of 2022, whereby the petitioner was whereby the respondent authorities were directed to consider the issue of condoning the age of the petitioner in the event an application is so filed for the subject post, which reads as under quote unquote by paragraph full 9 to ya to paba para ba order to silo para at page 84 to quote for as it appears that pursuant to the aforesaid order, the application of the petitioner was allowed to participate in the selection process, which earlier, because of the age limit, he was not allowed to submit. His application was not accepted. And pursuant to his participation, the petitioner was also selected and appointed accordingly. However, later on, it is further apparent that the OM dated 3/5/1951 provides condonation of age. Relevant paragraph of the affidavit filed by the state respondent number 2 reads as under A. B to B, page 85. B B till D to B 88. On page 89. The stand of the respondent appears to be that though the provision for condoning the age is available, however, instead of exercising the same due to oversight, the petitioner was given was allowed to participate in the selection process and accordingly was appointed. However, upon realizing the same, his appointment order was later on cancelled. It further appears that in respect of similarly situated employees, Dr. Dipali Kharkatari and Binoy Kharkatari, page 78, 79 at Paba, who were also similarly situated as that of the petitioner, was also appointed as assistant professor after condoning their age. The relevant paragraphs in this regard, as reflected in the affidavit, in the additional affidavit filed by the petitioner on 9/4/2024, reads as under, quote unquote, for paragraph, page 75, 14 paragraph 2. Considering that this court had directed the state respondents to consider the application of the petitioner for condoning the age objectively and keeping in mind that the office memorandum applicable prescribes the exercise of such power, which having notice has been exercised in respect of similarly situated two persons who had also, along with the petitioner, participated in the selection process and had requested for condoning their age. This court deems appropriate to dispose of the instant writ petition in the interest of justice by directing the respondent authorities to re-examine the issue as relating to the age condonation of the petitioner in respect of the subject post. In the event, no, I think it is already there by taking into account the subsequent application which the petitioner will file within a period of 10 days. 10 days from today, incorporating all subsequent facts which has been stated in the petition. Upon receipt of the so-and-so, the respondent shall dispose of the application strictly in accordance with law within a period of 2 months from the date of receipt of the certified copy of the order.
Only my prayer is whenever the representation will dispose of that, can be taking into account of this similarly situated person who is in favor of whose melody.
I've already said.
One thing, my lord.
That's why I have said that in your application you bring all this.
My lord, one thing, my lord. Lordship, my lord, probably
by taking into account that similarly situated dispose it of. Yes.
Was initial by selection process. That is, my lord, 26/7/2004, my lord. I was working since 2020.
Have I not said that?
It is, my lord, the lordship has mentioned probably 22, my lord.
No, because your synopsis only says about that.
No, my lord, this is a subsequent text, my lord, I have mentioned.
No. What subsequent facts? If your appointment is 2004, it should be mentioning. Yes.
By a selection.
Anyway, I'm not saying all that.
My lord, the problem will arise because
Yes.
I am working since that period. That is why, my lord, this difficulty
in your
arise.
submission, I may say it.
Yes, my lord, para number 2, my lord, I have mentioned, my lord.
Para number?
2.
Of where?
It is appointment letter also.
Para number 2 of where?
Is my writ petition, page number 10, my lord.
P. Mohantor submission of Lakhidiba.
And annexure document also there, my lord. Annexure 1 is linked to that effect. I was interviewed along with the other persons.
Mr. Mohanto further submits that pursuant to an
Selection
process, the petitioner was appointed to the post of
Assistant Professor
Boro language on
26/7/2020 to 2004.
26/7/2004. Where is that date? Okay, I got it. On 26/7/2004.
Yes.
Non-sanctioned post.
There's a, yes, obviously non-sanctioned.
Within bracket, non-sanctioned post. That's all.
This is the difficulty arise because there are no posts. So where estimate the post will be created
Anyway,
and I
next.
continue.
Highly obliged.
Mass obliged, my lord.
I wanted to mention one item, my lord. It was mentioned as.
Mentioning time is over,
My
Mr.
lord, I am
Counsel.
not mentioning, my lord. I just point out to your lordship. Item 16 and 71 mentioned by the other side, my lord, without taking my consent, my lord.
Item
16 and 17, my lord. My 17 is, my lord, 2017 contempt matter, my lord.
You are for the respondent.
Yes, my lord.
You are
In the-
Mr.
A.K. Maheshwari. So may I pray the item may be taken up day after tomorrow. I have taken the consent of.
All right. It will be day after tomorrow. Okay.
Much obliged.
And you had make a mention in the morning. Why have you said that with consent?
No, she did not say that like that.
A miscommunication between me and Enric attorney regarding consent.
Please be mindful next time, because this court takes everything that comes out from the officers of the court very seriously. So don't. Yes,
Contempt matter may be listed first, my lord, so that item.
Mr. Maheshwari, we have taken note of it. Yes.
My lord, in this matter, my lord, Mr. T.C. Sutia will argue the matter, my lord. And my lord.
Yes, what happened?
My lord, he was on leave due to his.
He was?
He is on leave, my lord, due to his daughter's marriage, my lord. And therefore, my lord, matter may be adjourned for the day and fixed on 19th of March, my lord.
All right.
And the words had been made, my lord, to dispose of the honor.
Yes, my lord.
Only for rechecking of answers.
You are Mr.
And Sharma.
Heard Mr. N. Sharma, Learned Counsel appearing for the petitioner. Also heard Mr. D.K. Roy, Learned Counsel appearing for
2, 3, 4, and 5.
2, 3, 4, and 5, and MS R. Barwa, Learned
Standing Council Secondary Education.
Learned Standing Counsel, SEBA,
Secondary Education Department.
Secondary Education Department. Mr. So-and-so, Learned Counsel for the respondent, submits that Mr. C.C. Sutia is conducting the brief for the respondent. However, due to his daughter's wedding, he is he's on leave presently and accordingly seeks a short accommodation, which is not objected by the Learned Counsel appearing for the petitioner. Prayer is allowed, relist on such and such date.
9.
Item 12.
Lordship, in this matter, I was supposed to file an affidavit, just call for vetting. May I pay for a day or two to bring it on the.
Similar last order, 21.
All right, he's fairly submitting, it's already gone for vetting. Heard Mr. K.R. Padgiri, Learned Counsel appearing for the petitioner. Also heard Mr.
A.K. Ghosh.
A.K. Ghosh, Learned Counsel appearing for the respondent.
PNRD.
Respondent PNRD. Mr. Ghosh submit that the affidavit in opposition has been sent for vetting and is awaiting for receiving the same back for filing. In view of the aforesaid endorsement, the matter stands adjourned to such and such date.
Obliged.
Give a shot. You file it by then.
Yes, sir.
Item 13.
Yes.
Yes, where is higher education? Higher education? Yes, who is for, you're for 5. What about the others?
6 has not,
Huh?
6 has not entered appearance, Lord, despite receipt of notice.
Mr. Upamanyu, you are not aware?
Lordship, this matter, Lordship, A.R. Tavildar is looking into this matter, Lordship, any other day after a week, Lordship.
Who is looking after?
Lordship, A.R. Tavildar.
Okay. And 6 has received or not received?
Received, Lord.
Okay.
But
We can't force. Heard Mr.
Yes.
A. Ali, learned counsel appearing for the petitioner. Also heard Mr. D. Upamanyu, learned standing counsel, Higher Education Department, and MS. S. Dihingya, learned counsel appearing for the respondent number 5. Mr. Upamanyu submits that since Mr. A.R. Tavildar is conducting the present case on behalf of the standing counsel, on behalf of the Higher Education Department, in view of his personal difficulty today, the matter be posted on any other date. Prayer is not opposed, released on such and such dates.
Obliged.
Please, Your Lord.
Yes, Mr. Mohammed.
Yes, my lord. My lord, the respondent finance department has filed an affidavit on 10/2. My lord, we need to file one short reply because there are points we have to.
All right. Heard Mr. M. Mohammed.
K.
na?
Mohammed.
K. Mohammed, learned counsel appearing for the petitioner. Also heard Mr. P. Nayak, learned additional advocate general. Yes, anybody else? Mr. R.K. Talukdar and Mr. B. Talukdar. Please give your appearances. Huh? Mr. Mahmood Mohammed seeks a short accommodation to file reply affidavit against the affidavit in opposition file on behalf additional affidavit file on behalf of the finance department.
Minor.
Prayer is allowed to repost on such and such dates.
Lord, can it be on 5th of March? 5th of March.
Yes.
5th of March. And before.
Mr. 30 and 31.
My lord, may kindly pass off the matter for the time being.
All right.
Next is on his way.
Time being, Mr. Pegu. Yes. Yes.
Please, your lordship. Lordship, I'm a retired constable.
Huh? Retired constable.
Yes, lordship. I was superannuated from service.
What happened to affidavits?
Received, Lordship.
Hmm.
From the
Instruction received not filed is no good.
But this instruction is not sufficient. As per our instruction, he has not submitted the documents, required documents. As because the pension papers cannot be prepared.
Lordship.
No, so what are you saying? He has to furnish the full particulars.
Yes, sir.
So as to process with the with the pension papers. This is relating to pension.
Yes.
Yes, sir.
So you give whatever you have to give.
Lordship, what happened due to marital state? My wife not live with me. We are separately living.
See that I don't know. These are it is for your benefit. But
Lordship,
you
what
have to
happened?
provide all the informations. If you do not give all the informations, how are they going to process your file?
Lordship,
So you communicate it to them.
I have communicated, Lordship.
Hmm.
I have communicated my wife by sending 2 times.
No, we
legal
are not
notices.
concerned about you and your wife.
I have submitted representation, Lordship. It is based on page.
Anyway,
24.
Ms.
24.
Barua, you file your affidavit.
Yes.
What can I don't think if the petitioner is not ready to file the particulars, we can't force also.
Yes.
So you file your affidavit, and on that basis, I can dispose it of.
Yes.
Okay. As prayed for by MS so and so, learned counsel for the respondent, and yes. Please give your appearances. Reports of Didiba আৰু এখেতৰ নামত adjournment to Didia that submits that instructions have been received and accordingly seeks a short accommodation for placing the same by way of return. Prayer is allowed. Repost on such and such date. A short data. I'm giving a short date. It's a pension matter. You file your affidavit. I'll dispose it of then.
Date may be fixed.
Mr. Counsel, please hear what is going on in the court. In all matters in this court, you are getting a date. You don't have to emphasize on that. I'll have pleasure. Yes, Mr. Sinha.
May it please your lordship, this is a case wherein we are claiming for a pay parity.
Pay parity, yes.
The issue was like this, your lordship. We are the BSc in optometrist. Then there was a grievance raised by us. And we ventilated our grievance before the pay commission, 7th pay commission. The pay commission, after going through it, has recommended that yes, this deserves a merit and this required to be considered. So accordingly, the health department was directed to make an in-depth inquiry and then take a decision and finally take a call in consultation with the finance department. And that recommendation of the pay commission was accepted by the cabinet, that by the committee, which is constituted after the pay commission. So that was also accepted and a cabinet decision was taken, and accordingly the health department and the medical education and research department has taken a decision that yes, the grade pay of 6,200 is not warranted. It should be 8,700 because the other persons
Who has given that recommendation?
the recommendation the pay commission has directed. Accordingly, the DME as well as the government in the health and family welfare department has taken the decision and forwarded it to the finance department. But finance department has not taken any call as on till now. That's my.
Please, Your Lordship. Your Lordship, Mr. B. Gogoi appears in this matter. Your Lordship is not available today due to medical emergency, Your Lordship. Prefer short accommodation, Your Lordship.
Only thing is consideration. Recommendation is already done.
The finance needs to take a call and they need to come to a conclusion.
I can dispose it of.
Let them come if they're not taking. Otherwise,
Okay, if you so insist, Mr. Sinha. Heard Mr. R. Sinha, Learned Counsel appearing for the petitioner, also heard MS.
R.M. Barua, Your Lordship.
R.M. Barua, Learned Counsel appearing for the finance.
Yes, Your Lordship.
Finance, she seeks a short accommodation on the ground that the conducting counsel, Mr. B. Gogoi, is unwell, is indisposed to take it. Yeah? Prayer is allowed, repost on such and such day.
For hearing item number 18 and 19.
Yes, Mr. Goswami.
Now I think the timing, the other side is.
Yes, call. Why are you not calling? 30. Kuntu Haidu, 30-31. This is the admission. Are talking about admission? Yes, what is this, Mr. Ma?
My lord, this is regarding the absorption of the two petitioners, 30 and 31. The same prayer in both the writ petitions. So, my lord, may kindly note down. This first one is G.D. Sanjay. He was appointed as SI BSF.
Yes.
And posted at Gwalior.
Yes.
Takanpur Gwalior on 7/2/19.
Yes.
7/2/19, and he joined in service on 25/3/2014. 25/3/2014.
Where are these dates available?
Yes, page. It lordship makes kindly see page 5. Para 3.
There's no list of dates given here. No, in the petition, there's no list of dates.
Yes, it is given.
I'm not getting it in my file.
In the title page, after 2
Synopsis is there.
After 2 pages.
Okay, I've got it. So is this date available here?
Yes.
7/2/19 is the appointment.
Date of appointment.
Date of
SI.
appointment. Yes.
And he joined
on
25/3/2014.
That date is not given here.
No.
You are referring to a date and the date is not even there in your list of dates. Where is that date?
Kindly see page 5.
Mr.
Page 5.
Mr. Mahmood,
Yes.
What is the requirement of giving list of dates? For putting the dates which has some relevance, correct? Now you are referring to a date, you want this court to take note of the date, but that date is not even there in your list of dates.
Yes, appointment letter 7 to 19.
That is there, but what about
Yes.
the other date,
Yes,
when, the
16.
date of joining?
Yes, 16.
Mr. Mahmood, you're not responding to the question that is being posed by the court. You see, the whole idea of giving a list of date is to give all the relevant dates, correct? For
Yes.
convenience of the court, isn't it?
Yes. And 7 to 2019, he was appointed and he joined on 20. Then he joined on after few days. That is
When he
21 to
joined?
14. Then notification, Lordship may kindly see, that is page 19, 20 and 24. 19, this is the circular. Kindly see, filling up of group B and C posts, non-gazetted, non-ministerial, combatant post on deputation basis in BSF engineering setup. So this was the notification circular was circulated among the eligible candidates that who are interested, they may submit their proposals for appointment as junior engineer. So this notification said that those candidates who are eligible, they may submit their biodatas or names or applications for the appointment of
Mr. Goswami, you are for?
junior engineer.
Respondent, ma'am.
I'm admitting this matter. This will take a lot of time.
What I am saying, now,
Yes.
the petitioner was appointed for deputation, that he was initially appointed as a SI, Malo. Subsequently, there is a notification, just now your lordship pointed out by learned counsel for the petitioner. There is an advertisement for filling up the post of junior engineer. The eligible candidate of the force, BSF force also applied. They applied, they selected. That is a deputation for the post of for 3 years.
Very well, but this matter requires a full-fledged hearing.
That is why
Today the
I am
matter-
going to point out
Mr.
yeah,
Goswami,
why the matter is urgent.
Very well, we'll give you a short date. Mr. Goswami, we'll give you a short date.
By 22nd, the period of deputation is going to be.
It cannot be like that.
What can it be?
Sorry.
Thursday, Malo?
Let us see. I heard Mr. M.U. Mahmood, learned counsel appearing for the petitioner. Also heard Mr. Goswami, learned counsel appearing for
The respondent in item number 30.
in item 30, all respondents. And yourself, Mr. Pego? So in 30 is Mr. Goswami and in 31 is Mr. Pego. Just look at naam to the matter requires full-fledged hearing. Admit no formal notice in view of the fact the respondents are duly represented before the court. Considering the urgency canvassed in the matter be posted in the hearing, posted for hearing on the date.
Going to be over by 22nd of this
Yes,
month.
date is given. Yes, next.
Well, can it be before that, Mal? By 22nd, the deputation period is going to expire, Mal. The next week, Mal, there is the urgency. That is why my humble prayer for Lord says, Mal.
26th. We'll see what happens. Next.
Oh, they are enjoying the stay, Oga. That is why
You have not come for a stay vacating, Mr. Goswami.
the detailed affidavit is there,
Yes,
Mal.
next.
For hearing item number 18 and 19.
Yes, Mr. Gogoi?
Madam, these are matters of 2014. I am challenging a dismissal to CRPF personnel matters.
Yes. On what ground?
Disproportionate
Punishment.
disproportionate matters.
Hmm. Yes.
Disproportionate, that's all, madam.
So that's a limited
Limited.
campus.
Yes, madam, limited.
Yes. The principles are well known. It has to be proportionate to the gravity of the offense.
My lords.
Correct?
In fact, my lords, they were given, if lordship comes to item number 1.
Item number 1?
Oh,
the first item.
First item,
448.
448.
Yes.
The petitioner is a gallantry award winner. He joined the force in 1998 and had a service of almost 98 to 2000. 98 he joins, in 2008 he gets a gallantry award.
Only thing is, again, that the search, there is no search against the item 1, my lord. There is a FIR was filed, my lord, against them, my lord, and there is no search against the item 1, my lord. The next one is search that, my lord. That case, there's criminal case pending, my lord.
So what happened?
I just indicated this.
This actually what had happened, these two sepoys of CRPF, madam, they went outside during the duty hours, madam. They went to withdraw some cash. While on the way to get cash, to take out cash, madam, they entered into an oil depot to take some fuel, madam, to buy some fuel. So there was some alteration, and there was a police case filed, madam. In this police case, madam, petitioner, the first case, madam, the petitioner was not charged sheeted, madam. Though the case was charged, he was not named, madam. Then he was acquitted, and he was suspended, and the disciplinary proceedings, my lords, started later on, my lords, in the month of June, my lords. Two articles I was charged with 2 articles that I had deliberately remained absent, which makes me unbecoming of staying in force. And second, my lord, I went out, had a quarrel. In a condition of under the influence of alcohol, I created a scene and I was at.
So what is shockingly disproportionate?
Disproportionate is, my lord, I went out. That's a fact, my lord. But the second issue which has come, my lord.
You were also consuming alcohol.
No, my lord, that is not there. That is just the allegation put to me.
What is the punishment given ultimately?
Dismissal, my lord, with no pay benefits.
Complete. That's the major.
That's the major, my lord. And my lords, while
and there under the guidelines, what is the punishment prescribed for such types of misconduct?
My lord, if admitted also.
No, what are the prescribed form of punishment for such type of misconducts? It must be prescribed.
Dismissal is the section 11, madam.
Section 11, madam. There's a dismissal.
Dismissal is also there. First thing, the dismissal.
Section 11(1) is
reduction of rank, madam. All etc. is there.
We don't have it.
I'm handing over my book.
Please say out the name.
CRPF Act 1949, read with rules of
Central Reserve Forcefully, sir.
Section 11.
11, madam.
Library part you have. Yes, section
11, madam. 11(1).
Nigerji library पर लोहे को common.
The
Section 11.
Yes, ma'am.
Yes.
The commandant or any other authority or officer or as may be prescribed may, subject to any rules made under this act, award in lieu of, my lord, or in addition to such.
You are going straight to section 11. You
11
first
one.
come to more heinous crimes. What are heinous crimes?
Heinous, my lord, is section 9.
Yes. So you have been the misconduct that you are accused of is what? Is of?
Is of, my lord, is of 9.
Misconduct.
9.
Yes.
Just 9, my lords. For assumption, my lords, it will be G.
Being a sentry sleeps upon his post or quits it. No, not that.
And my lords, H.
Leaves his commanding officer or his post or party to go in search of plunder. How is that relevant? Which is the misconduct? Which is your misconduct?
Yes.
Mr. Gugoi, you're not doing...
Exactly, my lord, what had happened, my lord. They didn't, the order.
Now let us see your show cause. First matter, let us see what have you been charged of. Yes,
Lordship will find it page number
28. Section 11(1) of so and so by which the image of discipline so and so. Let's read this. Page 29.
The force number so and so, my lords.
Yes, please.
JJ Gogo and force number so and so Biplab Bora, Group Center CRPF Khotkoti, while being posted as so and so man had committed an act of disobedience, neglect of duty, remissiousness in the charge of duty, and other misconduct in his capacity as a member of the force under section 11(1) of the CRPF Act.
Yes.
In that, in that so and so force number so and so while on RP duty at gate number 2 at so and so hours, and force number so and so being on quarter guard duty and so and so date, both the employees were found absent by force head number so and so, my lord. Despite
Yes.
of group center, despite search within the group center premises, the above personnel could not be found. The act of both employees in leaving their place of duty to go outside, even when they were detailed on sensitive duty such as active duty, quarter guard, is against the good conduct of the force and is in violation of the orders and disciplines of the force.
Okay. So one is that you've been absent of duty.
I was there, my lord. I attended my duty, but when they went to check at that point of
So
time, I was
absent himself without leave would fall under 10,
not. My lord.
isn't it? 10M. Absence himself without leave or without sufficient cause or overstays. That we are not concerned. I think your charge 1 is 10M. Yes or no, Mr. Medhi?
M, my lord, because it speaks about absent himself without leave.
Correct.
Here, my lord, I was on duty. I was charged. I was on duty, but when they come to check, well, I was on active duty. This will something different, my lord. If I take a leave,
absent himself without leave.
I mean leave, my lord.
You have not taken leave and you have absent. You went. You were absent from duty
for a certain period. I went outside, my lord.
So-
That is admitted, my lord.
So this
Because their campus did not have these ATM facilities.
Mr. Gogoi,
Madam.
I'm only trying to relate as which is the misconduct that you have been alleged of.
My lord.
What you are showing me is of the punishment 11(1). 11(1) prescribes punishments,
Madam.
right? But it has to correlate to a offense.
My lord.
Offense are given under 9 and 10. The 9 are more heinous offense and 10 is less heinous offense. Now, if your offense falls under 10, then perhaps the punishment that has been given to you may not be proportionate.
My lord.
Are you understanding what
I
I'm trying
got
to
it,
say now?
I got it, my lord. But
So now please help me understand what is the offense that you have been charged with.
my lord.
What is the offense? Because Article 1 says that both the employees were found absent. Despite search, the above force personnel could not be found. The act of both the employees in leaving their place of duty to go outside, even when they were detailed on sensitive duty, such as active duty, quarter guard, is against the good conduct of the force and is in violation of the orders and discipline of the force. Now, where does it fall?
Act of omission, my lord, see, refers to being arrested. Uh-huh. No,
Will it come under age? Have they discussed it somewhere? You have to find it out. And let us see Article 2. Why are you both not ready with the basic fact of the case? This is what you need to know. All matters cannot be just adjourned. These are the basic. You see, your whole premise before this court, your opening statement is that the punishment is disproportionate. Correct? Now, if you have to establish your case, you have to link it to the offense, right?
My lords.
Only then this court can apply its judicial mind and come to a finding whether the punishment awarded is proportionate or not proportionate. Now, this is why I'm trying to ask you, what is the offense?
My lord.
Which heading would your offense come?
My lord, my argument was, I came prepared with some different.
See, you as a counsel, you cannot just argue in the way you have prepared. You have to also perceive as what are the questions that may be posed to you.
My lord.
Now, if this is your main case, then the first thing that you need to show before the court is under which offense of the CRPF Act you are being booked. What you are showing is the 11(1). 11(1) is not an offense.
11(1) is the imposition.
Correct. Punishment.
Punishment, my lord.
So, that is why I'm asking, what is the offense you have created? Obviously, that reference must be somewhere. You people have not even read the brief. Mr. Medhi is of also no help.
I don't know. I read it too bit. too much, my lord. So it's called messed up.
No, I don't know about that.
Uh,
This is the basic thing
Can
you
Lordship
need to
take it up,
address the court.
Lordship can take it up for final disposal on Tuesday, my lord.
And there is no, but these are the basic things. I
understand,
think you
madam.
should have
I
had it
understand.
with you. You're not even having the basic facts before the court. This matter could have been disposed today, right now. It's only a short issue. All that this court is to apply the test, whether it shockingly shocks the conscience of the court as regards the quantum of the punishment compared vis-a-vis with the gravity of the offense. Now, for that, I'm asking, what is the offense that you are being charged with? Both the counsels appears blank to me.
He's authorized absent, my lord. Authorized absent.
I was
on his on duty.
That is falling under 9 or 10.
My lord, there's some.
Mr. Mehdi falling under 9 or 10.
it's 9 over.
Because hobo no hobo is something you should both have discussed it and looked into your brief, not before the court. You are wasting the judicial time of the court, counsels.
My lord, I will outrightly reject because I am confessing that I don't fall under 10.
Correct.
Don't fall
Now,
under 10.
if you're not under 10, then you fall under what?
9, my lord. Lordship has correctly pointed out 9.
9.
M. my
You
lord.
are appearing
Apportion.
for whom? For the
Petitioners, my lords.
for the petitioners.
lords.
So you mean to say that you have done a more heinous crime?
No. 9 is less heinous. 10 is more heinous. 9 is more heinous, 10 is less heinous. Yes. 9 is more heinous, 10 is less heinous. What I'm trying to say, my lords, 9 which spells out the heinous crimes, my lords. I'm not a deserter. I just want
Now the dismissal from service is a grave punishment.
Yes, my lords.
So that is for more heinous crime or for less heinous crime?
More heinous crimes, my lords.
So, but you are saying that you fall under 9.
No, 10, my lords. I fall under 9. 10.
Mr. Gogol, what are you saying?
My
These are all live streaming going on. You please go back and you see, you check what you are saying.
Check this, he's authorized absent.
1 second, Mr. Mehdi. Mr. Gogoi,
But this is something.
Mr. Gogoi, you recheck the video recording. You please hear yourself.
I just corrected myself.
You please hear yourself. When do you want it?
24. Tuesday.
Since the learned counsels appearing, since both the learned counsel appearing for the parties is not being able to point out before this court as regards the nature of the offense and under which appropriate section of the Central Reserve Police Act 1949, the petitioner has been booked, relist on such and such date. Yes, next.
No, 24.
Next.
24. All right, my lord.
Yes. Who's there for the petitioner? None appears for the petitioner on call. Heard, Mr.
B Sharma, madam.
P.
CGC.
P, na?
B Sharma.
B.
Madam.
B. Sharma, Leonard, CGC. Relist on Friday under the column for dismissal.
Okay.
If on Friday also there is no appearance, we'll dismiss it.
Minor.
It's an old matter, so I'm giving them one chance.
But there is also no merit in this case.
So
also.
we'll see on Friday.
Minor. Okay. Okay.
Yes, Mr. Sharma, this is that matter. Yes, now let us see what is the issue pending before the apex court.
In this writ petition matter, the order which has been challenged.
In November 24, the submission was made. But what has happened after that? Do you have anything?
Yes, I provided my lord a copy of the order, my lord. The last order has been dated November 2025, my lord. Thereafter, the matter has not been listed.
Okay.
That is my
Very
submission, my
well.
lord, because-
Very well.
Yes, sir.
See, this is why I didn't immediately adjourn because you see the matter is of 2017. It is difficult to adjourn it like that. Now the order can record these informations. You understand now, Mr. Sharma? Because otherwise there was no requirement for keeping you both waiting for this one.
Absolutely.
Heard Mr. P. Sharma, na?
M. Sharma.
M. Sharma, Learned Counsel appearing for the petitioner. Also heard Mr. J.K. Goswami, Learned Additional Senior Government Advocate for the state. It appears that the it appears that earlier the instant writ petition was adjourned on 7/11/2024 on the ground that related issue is pending before the apex court. Today, when the matter is called, Mr. M. Sharma, by referring to the orders of the apex court passed in the related case before the apex court in so and so, states that the matter was last listed before the apex court as per the website, as per the information available from the website on
3rd of November 2025, my lord.
3/11/2025. Noting that the matter is still sub judice before the apex court, the matter stands adjourned sine die. Parties are given liberty to approach before the registry as and when there is development before the apex court. So you inform it, there's no point of
True, my lord.
keeping it.
Because the
So you
order
go, any one of you, when you come to know, you just bring it to the notice of the registry.
My lord.
And then the registry will place it before the court. And the orders of the apex court dated 16/1/2024 and 3/11/2025 are kept on record.
22.
Your lordship, kindly pass over the matter for some time, your lordship.
Okay.
Thank you, your lordship.
24.
Yes, Mr. Bora.
My lord, the latest instruction I have received, the matter is that, my lord, the petitioners is the Association of Dental Surgeons. So initial their claim was that they did not have any promotional avenue. They did not have any promotional avenue. That's why they are praying for framing of rules and promotional avenues, my lord. So the rules, my lord, that is, as I have received the latest instruction, the rules that has been gone to the personnel and finance department.
Okay, anyway, your counterpart is not here.
Yes, my lord.
So have you filed your affidavit response or not in the contempt?
Yes, my lord. In the
Response are there.
Yes, my lord.
So I think because of this development, perhaps the matter may be kept.
Yes, my lord.
Let us see what happens.
Yes, my lord.
But do you? I don't think I need to address this also in this
Yes, my lord.
order.
Not
Huh?
required now.
You give it on the next date again.
Yes, madam.
None appears for the petitioner on call. Heard Mr. So and so DP Bora, Learned Counsel appearing for the respondent. But this is a contempt, right?
There is contempt and subsequent writ petition also, my lord.
Mr. Bora submits that as per the information received from the Office of the Joint Secretary to the Government of Assam Health and Family Welfare Department, Dispur, by letter dated 28/12/2025, it appears that the following steps are undertaken. A to A ko diba. Okay, sir? You are appearing, Mr. Chakraborty? Some development is said to have been done in the meantime. So you take a breath. You want a glass of water?
Ground floor, man. So, what happened is it is of 2007 only. 2010 judgment came. Second date, this is second date. Here also they said that 18 they file affidavit saying that draft rule prepared and all. This is 26 again saying the same thing, madam. They have to do it. Seriously,
I have water.
Yes, thank you.
Mr. Bora, where is the order of this court? Which page? Is it page 17?
My lord.
Is it page 17?
In the content.
Yes.
Page 17?
Order of the court.
Yes, yes. In
Yes.
view of the above, this writ petition is disposed of with a direction to the petitioners association to file a representation before the respondent number 1 along with a certified copy of this order and a copy of the writ petition and the rejoined. But where is what has been decided here? The direction is, I'm of the considered view that the petitioners association has been able to make out a case for issuing a direction to the state to suitably amend the rules, providing a separate cover for
Yes.
dental surgeons with suitable promotional avenues for them in the line of the rules framed by the government's ones. In view of this, it is a direction. But there was no time frame given within a reasonable period of time. It
Reasonable
says.
time.
And in the meantime, in fact, my lord, some sort of relief have been granted to the petitioner association by creating some post.
See,
my lord,
Mr.
they have been
Chakraborty,
granted
problem
promotion.
is it's a contempt jurisdiction. I
No,
understand
there is
that
a writ also, my lord.
Huh?
There
There is a writ.
writ is also.
I have taken the contempt first,
Right.
but here it appears that they are doing something. So I don't think this is a case where we can say that they have been willfully or deliberately not doing it. And there is also no specific time period, reasonable of course. But so on that, I
17
don't think
years,
that.
my lord, 17 years has gone
I
and
don't think.
my lord,
it
2018
seems-
affidavit, 2018
Now,
affidavit.
what do you want me to do? Take up this contempt?
My lord, no, my lord, they have to do it. Let
They
them
are
do it
saying that
seriously,
they
my
are going to
lord.
do. That they said that the draft service rules
It has been
has been
filed.
prepared and endorsed to personnel department. Mr. Bora, can you give us a time frame?
My lord, because it is, I am representing my lord health department, but it is with the personnel department. We have sent it, my lord.
No, in the main case, the personnel departments are not a party.
No, no.
Arvita case
My
assessment, sir.
lord, when the rule is to be framed, it has to go to many department, my lord. There has to be a cabinet memorandum, my lord.
See, you
That-
have to be also mindful that you cannot be merely taking time. Time in the sense time in complying, correct? It's
In
a,
fact,
the judgment is of 2017.
It-
We are in 26.
Yes, my lord. My
So-
lord, in fact, to redress the grievance of the petitioner association, in the meantime, some posts have been created and they have been promoted.
No, my lord. Only a notification has come.
Yes.
Only the present my lord, dental surgeon, they have been given the next. Well, the rule has not been amendment. So meaning
Yes.
thereby,
Rule has not been amended, but they have been given promotion, one promotion, my lord.
direction was for 2 promotions by amending the rule so that everybody gets it.
In the writ petition, you said you need some time to take some instruction. This is the instruction you have taken.
Yes, my lord.
Huh?
Yes, my lord. This is the latest instruction.
No, you said you need to take instructions on the affidavit in reply
Yes,
filed by the petitioner and therefore three. So is this your
Yes,
response?
This is the instruction of 28.
You do one thing, you file a detailed affidavit, try and indicate a time frame in that affidavit.
Yes, my lord.
At least let us have your stand in the affidavit, and then maybe on the next date we may
My lord, my lord,
consider finally giving a positive order
my lord.
if a time frame comes. And I think in the writ petition, all the other required respondents are already arrayed as respondents or not?
My lord.
Who is left?
Only the health department, my
All
lord.
department will do it, my lord.
No, this is rules.
That's why when rule framing, my lord, it has to go so many departments. It is not necessary that writ petition all should be party. It should go to the parent department and they should,
It's only the principal secretary of the state is there.
Principal Secretary of the Health and Family Welfare Department.
So you give a detailed affidavit. Pursuant to the last order dated 7/11/2024, Mr. DP Bora, Learned Standing Council, Health Department submits উপর এখানে question না instruction এটা ঠিক লগাই দেয়া that he has received instruction এখানে so and so perusal of the instructions indicates ABC করে দিবা quote unquote করে দিবা এখানৰ পৰা চাই লবা let a detailed affidavit incorporating the aforesaid instruction as well as a time frame by which the entire exercise can be completed, be indicated. So you find an affidavit indicating, I've passed the judicial order to that. Now you give it on the next date. Let us see what you give. And please take the appearance of both parties.
Date may be given.
Yes, yes. Yes. Did you update too?
Yes, my lord.
Mr. Bora, can we keep this or you want it? You have a copy?
Yes, my lord. I have shot him also a copy.
Item 25.
Obliged, my lord.
May I please before Lordship,
Yes.
this case may be taken at 2 p.m. or day after tomorrow, my lord.
Why?
As my lord conducting advocate Deyai Borvia with briefs is out of station now. Perhaps Poltonberger, my chamber. I communicate.
Huh?
I have communicated with him. He's under fever at Poltonberger chamber. Has not come to this.
He is suffering from fever.
Yes, madam. He's contacting at door in this case. But
Who is the arguing counsel?
yes, sir. Yes.
Who is arguing?
My lord Jai Borbe. Day after tomorrow, my lord, at 2 p.m.
At 2 p.m. his fever will go down.
Then I will argue. Taking this brief.
But then if you can argue, why to do a trial run first? Huh? Why? Yeah, you could have argued the matter. It's a 2018 matter.
My lord, actually.
Now that you are volunteering yourself to argue, you argue now only. By two, I don't think anything is going to change. The records were with you.
Actually, we have no case brief with me. That file is.
All right, when do you want it?
Day after tomorrow, my lord.
May not be because already many matters are fixed.
19 নহয় জানো day after 19 CPC matters get all fixed নাই জানো. So we give another date.
26.
It is submitted that Mr. J.I. Barbhuya, learned counsel, appearing for the learned counsel, who is learned arguing counsel, for the petitioner is unwell today and has not been able to come to the court. Accordingly, a short accommodation is sought, which is not opposed by MS so and so. Learned CGC, na? So and so. Repost on such and such date.
26.
It is, however, made clear that on the next date of listing, in the event that so and so has not recovered, alternative arrangement for arguing the counsel on behalf of the petitioner be made, since there are other counsels on record as well.
26.
Lordship, here in this matter, Lordship, the views of the pension department are yet to be received, Lordship. So may I pray this matter to be listed after, Lordship, 2 weeks, Lordship?
All the affidavits appears to have been filed.
Yes.
This court had asked for the administrative view from the Administrative Reforms Training Pension Public Grievance Department. Why was that required?
Lordship, because here in this petition, Lordship case, Lordship, the petitioner, from 1998, Lordship, he took leave for medical reasons, Lordship, and thereafter he never came back to duty, Lordship.
Oh, this is that case.
Yes, Lordship. So now, Lordship, after almost 24 years, he has filed this writ petition, and there was no records available in our department pertaining to his service, books, anything, Lordship. Nothing was there, Lordship. So, Lordship, the pension department has submitted a few documents based on which, Lordship, the department has provided the provisional family pension, because after filing of the writ petition, Lordship, the petitioner expired, Lordship. So, Lordship, now, Lordship, the views of the pension department is required for the final pension and GPF and GIS benefits, Lordship, to finalize that.
But already they have released the provisional pension also. Now petitioner is receiving provisional pension and also release some area salary also.
Okay, then let him complete his instructions. As prayed for by Mr. D. Upamanu, Learned Standing Counsel, Health Department, to the effect that the views from the Administrative Reforms, Training, Pension and Public Grievances Department is still awaiting, relist on such and such date.
Reported date, Lord, sir.
6. Obliged.
Obliged.
Item 27.
I think today we should, this is the same matter?
Yes, we know. Directed to file our
Let us hope that.
I think we have the time also.
Yes.
Yes?
We are directed to file our written argument, my lord. The petitioner has already filed their written argument. So we have also prepared their written argument, my lord. Today I am going to file it, my lord.
You are filing it today?
Today, my lord.
You have written argument for dismissal? Yes. Mr. Chalya, your written argument is this one?
Yes,
This is the one.
I have made my submissions also.
Yes.
on that.
Now I have it. And Mr. Das, today was your turn otherwise, isn't it?
Yes.
Yes. It's ready? The arguments are ready?
Please, let him.
Give a copy to us also.
Actually, the oral submission will be.
But
required.
a little submission will be definitely required because I generally try to dispose of dictate the judgments in the court.
Right.
So definitely it will be required. Just can you briefly refresh my memory?
Well, that I will. From the written argument, my lord. I'm drawing your lordship attention to a para 2, my lord.
Yes.
Para 2. That is the initial, that's how the matter has come up before this honorable court.
Yes.
That the lead petitioner actually Hitendra Gomar Pukon, pursuant to his selection and appointment, he joined the Power Grid Corporation of India in June 2010. During the period from the November 2016 to February 2018, he was posted at Fulbari, Garu Hills as chief manager to look after and oversee the construction work of a Fulbari substation under NRC. In course of time, NRC means Northeastern Region Power System Implementation Project. In course of time, it was detected that the lead petitioner, while execution and implementation of the aforesaid project, he had committed serious illegalities, failed to maintain absolute integrity, and also acted in a manner which is unbecoming of a public servant, but misused his official position, and also acted in a manner prejudicial to the interest of the power grid. Consequent upon which the chairman and the managing director, as the discipline authority, Power Grid High notice dated 17/5/2019, finally decided to initiate inquiry under Rule 25 of the Power Grid Conduct, Discipline and Appeal Rules 2020, and issued a statement of articles of charges along with the article of charges, the statement of imputation of misconduct, the list of documents, and the list of witnesses were also furnished to the petitioner, copy of which is available as Annexure A to the petition from page so and so, my lord. Then next this one, the next my lord, these are charges are my article of charges, my lord, that I have quoted it as in paragraph 3, my lord. Articles 1, 2, 3, and 4, my lord. 4 charges, my lord.
Let us read.
Right.
Read. Article 1.
Article 1. Sri H.K. Pukon, employee number 51252, Deputy General Manager.
The reading part, if you want, Mr. Das can also read it for you. Yeah, okay. Because I wanted to read this but only on, like, I don't want to keep it CAV. I have the time today. So let us make an attempt if we can finish the matter today itself. So that is why I'm reading it along with you all. And I think Mr. Chalia will also get a chance to give his reply. Otherwise, he will have to also go through everything and it will save all our time, I think.
H.K. Pukon, employee number Deputy General Manager 400, oblique 2020 KB, Balipara substation, was posted at a Pulbari under NRP SIP projects which effect from November 2016 to February 2018. During his posting at a Pulbari, he was looking after the construction work of Pulbari substation, and Srimati Nijumani Gogoi, wife of Sri H.K. Pukon, received rupees 2,37,000 through her bank account, bearing account number so and so of State Bank of India, 6 Mile branch, DS Road, Gauhati, from Messrs. Surya Choikia, a labor contractor engaged by Messrs. Nikon Executing Agency at Pulbari substation towards a hiring charge of art excavator JCB owned by her. Shri Pukon resorted to business with the working contractor under his control and misused his official position for personal gain. Shri H.K. Pukon had thus failed to maintain absolute integrity, acted in a manner which is unbecoming of public servant, misused his official position, acted in a manner prejudicial to the interest of the company, and violated or non-complied with the company's rules, policies, manuals, or circulars by the above acts of the omission and commission.
Power grid CDA rules. Power grid CDA rules.
That we have already.
We have
anything
given
like
it,
that.
yeah.
Affidavit in opposition.
Opposition,
The
okay.
opposition is there.
Okay.
Already.
Zakir.
But on commission,
Internet to matter. It is download Yes. No, I understand it's there.
That is available at
Of the affidavit.
In our affidavit.
It's all right. That is in part of the volume. I just want a separate copy. So if it's available online, I've asked him to download for my convenience.
In our affidavit.
Otherwise, in your affidavit, page number?
Page 226.
Page
226.
226. Second copy to tak di diyo apna. 226 hat.
The entire photocopies of this the dismissal proceeding that you have annexed in our affidavit of opposition.
Okay, okay.
City SK Pukon employee so violated the rules and the for so read with so of the power grid CDA rules. Article 2, my lord. City SK Pukon while posted at Pulubari under NRC projects deliberately concealed the fact of acquiring of two numbers of JCB by his wife worth of rupees 25,58,999 purchased on dated 3/2/2025 and rupees 27,18,959 purchased on dated 8/3/2017 while submitting his annual property returns ending on so and so respectively. Further, SK Pukon did not give any intimation as per CDA rules 16 while acquiring both the JCBs. SK Pukon does fail to maintain absolute integrity, acted in a manner which is unbecoming of public servant, acted in a manner prejudicial to the interest of the corporation, violated or non-complied with the company's rules, policies, manuals, circulars, and failed to report transaction concerning movable property. By the above acts of omission and commission, SK Pukon employee number so and so violated a rule 41 Roman 3, read with a rule 55, 524 and 16.3 of the power grid CDA rules. Then Article 3, my lord. SK Pukon, while posted at Pulbari under NRSP SIP projects, processed to a second and third renewing bill dated 29/6/2017.
Mr. Das, I have read it.
My lord.
I'm sorry, I went a little fast. But in sum and substance, these all four charges are in relation of your work while you were posted there in that project at Pulbari as Deputy General Manager, and you were looking after the construction work of Pulbari substation, right? Your wife is one of the contractor, and she had two JCBs. Which one of the allegation is that you had not disclosed this in your source, in your assets, in your assets disclosure, and plus the she had been given the job, and then monies were through bills have been given. However, these bills have not been properly assessed, verified. That there has been certain irregularities. Basically, misuse and abuse of the position. These are the substance and bringing a loss to the company. Correct. This is the sum and substance. Have I missed out anything? Yes. Then what happened? Then.
Malad, then on receipt of the notice dated 17/5 that para 4, malad, that will be very clear, malad.
Yes.
Para 4, malad.
Yes.
That upon receipt of the aforesaid notice dated of 17/5/2019, the lead prisoner by his letter dated of 6/7/2019 submitted his reply to the article of charges leveled against him, but the disciplinary authority, being not fully satisfied with the reply so made by the lead prisoner against the charges to which he is subjected, the chairman and managing director of the Power Grid Corporation by his two orders dated 2/9/2019 finally decided to hold inquiry proceedings against the petitioner and accordingly appointed Sri Vijay Kumar SSP retired CBI as the inquiry authority to inquire into the charges framed against the petitioner and also appointed Sri Arun Gogoi, Chief Manager Vigilance as the presenting officer to present the
So these procedures, I don't think any challenge to the procedure, no?
No.
So basic procedures have all been followed. You've got, you have given them the reply, the opportunity to reply, and they have accordingly replied. You are not satisfied, therefore you appoint an inquiry officer, correct? So that is okay. Now coming to inquiry, 6 witnesses and on behalf of management was examined.
And various documents were exhibited in support of the charges, and they were also thoroughly cross-examined by the charge officer.
What is the basic challenge?
Well,
what was the main challenge? What was the bone of contention for challenging the proceedings?
That actually they have in the repetition they actually they could not make out any
evidence.
Okay.
So that is a very very limited jurisdiction that this court has because this court is not sitting in appeal.
Or was finding.
So for that, you see, Mr. Cholia, in that situation, it has to be no evidence at all. So if this court finds that yes, absolutely no evidence of any whatsoever, then you are right. Then it is perverse. But if this court finds that there is some evidence, then this court cannot weigh those evidence and balance it and see whether they are sufficient or not sufficient. So anyway, that is the law, I think. If that is the only ground of challenge, then probably, Mr. Cholia, we can cut this short and you take me to the proceedings. Where do we get the proceedings?
Let
me see the proceedings, but because we've already seen the charges, let us see what are the evidence available.
That is my lord at page 195, my lord. That is the conclusion and findings, my lord.
Page
195, my lord.
195
of my affidavit opposition, my lord.
195. Yes, please.
Madam, I have gone through the evidence on record of the inquiry, arguments of presenting officer and charge officer. While the presenting officer has concluded that in the light of the evidence on record, the charges leveled against the charge officer are proved. The charge officer has denied all the charges, analyzing the evidence against the charge officer and the arguments put forward by both the presenting officer and the charge officer on its article charge. The conclusion findings are as under, my lord. Then article charge number 1, my lord. The fact that Sri H.K. Fukon, the charge officer who was posted at Fulbari under NRPSP CPA projects which have effect from November 2016 to February 2018 and was looking after the construction of the Fulbari substation is not in dispute. It is also established that Srimati Nijumani Gogoi, wife of the charge officer, received ₹2,37,000 in her bank account number so and so maintained with State Bank of India, 6 Mile branch at GS Road, Gauhati, from Messrs. Surya Soikia, a labor contractor engaged by Messrs. Nikon towards hiring charge of art excavator owned by Srimati Nijumani Gogoi. The details of such remittance are as follows, my lord. Then it has been established that a total amount of ₹2,37,000 was paid to Srimati Nijumani Gogoi in her bank account towards the hiring charge of art excavator. There is no document on record to show that the charge officer obtained any permission from the department for the business with the working contractor under his control. The charge officer, in his defense, produced an equipment rental agreement that is so and so executed between Srimati Sirajul Islam and Srimati Nijumani Gogoi for giving the art excavator on lease for a period of 36 months. Exhibit DD3. This agreement only established that the said art excavator was given on rent to Sirajul Islam initially for a period of 36 months at the rate of ₹1,30,000 per month. The charge officer, during questioning by the inquiry authority, claimed that he was not having the knowledge that the said excavator belonging to his wife was used at a Fulbari site. In fact, he had to many other works to attend like works relating to transmission line, profile, preparation, meeting with a senior officers at Shillong and for obtaining consent of the owner of the project, and as such, he was not going to the site continuously. However, when he came to know that the said excavator was being used at the Fulbari site, he immediately asked the driver of the vehicle to take away the same from the Fulbari work site. The search officer has further taken the stand that his wife was doing business independently and he had no knowledge as to under what terms and conditions and where she was utilizing the excavator. The contention of the CO search officer is not tenable. It was very well known to him that the art excavator belonged to his wife, and this had been utilized in the works under his control. He has admitted that when he came to know that the said excavator belonging to his wife was being utilized at the work, he should have at least obtained ex post facto approval from the competent authority for the said business by his wife. He also did not raise any objection in the transfer of money to the account of Srimati Nijumani Gogoi, which was done by the subcontractor on so and so, and so and so. It is worth mentioning here that the search officer in his signed statement that is so and so given before Sri Bhaskar Roy, manager, vigilance, NER exhibit D25, admitted that in April 2017, on the request of Sri Surya Soika, he has asked his wife to deploy her JCB at the work site due to non-availability of JCB at the Fulbari area in the interest of work as rainy season was commencing. This shows that he was fully aware of the business being done by his wife, who received payment for the works alleged to have been done by his wife through Sirajul Islam. It is thus established during the inquiry that the search officer, while working as Deputy General Manager at Fulbari under NRP SIP projects, was looking after the construction work of Fulbari substation, and Srimati Nijumani Gogoi, his wife, received rupees 2,37,000 in her bank account number so and so, maintained with SBI, 6 months GS Road, Gauhati, from Messrs. Surya Soika, a labor contractor engaged by Messrs. Nikon towards hiring search of art excavator owned by her. The search officer resorted to business with the working contractors under his control and misused his official position for personal gain. It is thus established that he committed gross misconduct and violated Rule 4.1, Roman 1, Roman 2, and Roman 15, aid with Rule 525 of the Power Grid CDA rules. Then Article 2, my lord, second article. As per the tax invoice dated 3/2/2015, Srimati Nijumani Gogoi, wife of search officer, purchased the art excavator for a total sum of rupees 25,58,909. So exhibit D17-1, 17/1. This art excavator was registered with the Transport Department, Government of Meghalaya, on 7/7/2015 as ML 10B 1838 in the name of Srimati Nijumani Gogoi, wife of Hitendra Kumar Fupan. Osoi Enclave, VIP Road, Borbari, Kamrup, Assam, Gauhati. As per Exhibit D72, for purchasing the art excavator, a sum of rupees 18,78,041 was obtained as a loan from Messrs. Sri SREI Equipment Finance Limited for a period of 48 months. A down payment of rupees 7 lakhs was made against this loan. Sri S.K. Pukon, the search officer, was a guarantor in the said loan and thus was fully aware about the purchase of the art excavator by his wife. He was thus required to initiate this transaction to the department as per Rule 16 of the Power Grid CDA rules. In the annual property return of the year ending 2015, the search officer did not mention about the purchase of the said art excavator by his wife, Exhibit D24/1. Although in the said property return ending 31/3/2015, the details of his family members as well as the details of the other assets acquired by him are mentioned, but no reference about the purchase has been given. It is also established from Exhibit D 17.3, D/3, that one more art excavator was purchased on the 8/3/2017 in the name of Srimati Nijumani Gogoi at a total cost of rupees 27,18,959. A sum of rupees 8,07,622 was paid as down payment and rupees 19,85,310 was taken as loan from SREI Equipment Finance Limited. As it appeared apparent from Exhibit D 17/4, the equipment finance documents have been signed by Shri Nijumani Gogoi as borrower and by the charge officer as guarantor. No intimation about his purchase was given to the department by the charge officer as is seen from Exhibit D 24/2. That is the annual property return for the year 2017 as on 31/12/2017. It may be mentioned that the said excavator immediately after the purchase was utilized at the Fulbari work site, which was under the charge of the charge officer and for which Srimati Nijumani Gogoi received a sum of 2,37,000 for doing the artwork during the period 16/4/2017 to 29/4/2017. The charge officer, during a reply to the questions by the inquiry officer as to why timely intimation was not given to the department as required under the Power Grid CDA rules, submitted that he was not having knowledge about intimation to be given to the department as per CDA rules for the assets purchased in the name of his wife. He has also taken the plea that since the registration of the vehicle had not been done with the Transport Authority till 31/12/2017, the acquisition of this art excavator was not mentioned in the annual property return for the period ending 31/12/2027. Exhibit D to 2017. Exhibit D /24/2. According to him, the registration of the said excavator materialized in May 2018, and he had intimated about this transaction in his annual property return for the year ending December 2018. The plea taken by the charge officer is baseless and not as per the requirement of CDA rules. In fact, he should have intimated the transaction within the specified period and should have also reflected in the same in the annual property return for the period ending 31/12/2017. The registration of the excavator is nowhere concerned with the actual date of acquisition of the vehicle. In fact, whether the excavator was registered or not registered, he should have intimated about this transaction under the provisions of.
So all the charges have been established. And it appears that there were sufficient evidence appears to have been there because even some vigilance had made an check and they have found certain discrepancies in regarding the project. And though initially it was not disclosed about these excavators, but in some return, I think you have, according to you, it is because that is the time you got it registered.
But this article 3, my lord, that will be more important, my lord.
Yes.
For this, the corporation was about to lose the amount of substantial amount, my lord, for the inaction on the part of this repeat, my lord. May I read my article 3?
Yes, yes. No, I've already read it, but you may point out if anything.
Page at page 201, my lord. From top, my lord.
Yes. Yes.
And this the last of that paragraph, my lord, last sentence, my lord. Since the discrepancies
were pointed out
during the vigilance inspection, the excess amount of 23,24,222 was recovered from the contractor after approval of the competent authority, my lord. This is most important because the bill was paid, my lord, without even making measurement of the artwork, my lord. Then
Yes.
ultimately this amount will have to be deducted from the contract or from the next bill, my lord.
Excess payment.
My absolute. This gross negligence, madam, not only this, but there's, it was, this company was, the corporation was about to lose this amount, madam, this pay, but this, you are the competent authority, madam, you are without making measurement or the artwork, madam, how the bill could be prepared, madam. He has prepared the bill, madam, where it was passed by him, payment was made to the contractor, madam. The subsequently on inquiry, my lord. Inquiry
right.
had to be made, my lord, then inquiry.
All
was
right,
made, my lord.
noted, yes. So then accordingly, all the charges were established.
The proof, my lord, then thereafter, my lord, this
Then
copy of this
was
inquiry
given
report
to him
that
for
he-
his
He has
representation.
replied, my lord.
He had replied.
Yes, my lord. 203. My lord. Then, my lord,
Finally, I think 217.
my lord.
217 is the order, no?
My lord. Good.
This is the disciplinary authority's order.
My lord. Good. 217. 217.
Type copy, I
My
think.
lord.
Even the disciplinary authority has fully discussed
My lord.
and says that absolute integrity acted in a manner unbecoming and accordingly. Ultimately, what is the
When this all the charges were proved, my lord. And the inquiry proceeding was conducted in the free and fair manner and giving all proportion to the
penalty of compulsory retirement?
compulsory retirement. So immediately fit case, my lord, for imposing the penalty of
Yes.
dismissal, my lord.
Yes.
But the authority, the disciplinary authority, by taking
Against this, any appeal filed?
my lord, appeal was filed, my lord. Appeal was also dismissed, my lord. The order passed by the disciplinary authority was
It is rules to paisla.
approved, my lord.
ঠিক আছে, ইয়াত আছে otherwise. Okay, appeal was not allowed.
Not, it was turned
So
down.
basically that the penalty was upheld,
Appeal, my lord.
right?
Appeal was held.
And then the writ petition filed.
Before that, they also filed a review petition, my lord.
That also.
That also, my lord, the review could not be.
Okay. Just give me
considered.
the page numbers of the appeal and the review.
My lord.
Appeal is at what page? The rejection?
Okay. The lottery for the 80 election as page 84 writ petition.
Page?
84 of the writ petition.
Writ petition.
Yes, Lord.
Page 84.
Yes, sir. Yes.
84. So this is the appellate authority.
Yes.
And the review or revision? Review.
Where
Which page is that?
you have to find the page 111. 111.
111.
Because this reviewing authority is the appellate authority, my lord, because that for that that could not be this review petition could not be considered, my lord.
Okay. Then, so your final, you can sum up your submission. These are the facts.
No, my lord.
So according to you, there is there is evidence,
My lord.
and on the basis of the evidence, a finding of guilt has been recorded.
Correct.
Correct? And the gravity, and also considering that the offense is grave,
Yes, my lord.
the punishment is proportionate. In
My-
fact, you say the punishment is less,
My lord.
right?
My lord. But in that petition, my lord, they have not made any allegation that the findings given by the inquiry officer is perverse, my lord, not
That
based on
is not
evidence from
there.
the court. That is not there. That is not there, my lord.
What is the ground urged in the writ petition?
That is, my lord. Yeah.
No, what ground have they urged in the writ petition, if not perversity?
There is
No specific grounds.
There is no any specific ground, my lord. For challenging this or.
Let us see the averment in the writ petition. Where does it start from? Page?
Page, their petition is, my lord.
No, the submission starts from.
Page 15.
These are facts. Page 18. Page 18, I think. It starts.
20, my lord.
I've given the
Okay. Anything else?
No, actually, it was that I have submitted already, my lord. On the basis of these findings given by the inquiry officer, my lord. It was all the charges were approved, my lord. If all the charges were approved, my lord, it is a very serious education, my lord, in the search, my lord. In the deputy, the rank of the deputy manager, he has committed this, practically. And
Mr. Goswami, Mr. Das is very, huh? Yes. Any authority you want to rely?
Judgment with the written arguments.
You have given?
Yes, good, my lord.
Just give me the page and the paragraphs you can indicate.
Page 9, my lord, I'm drawing you.
I think first is page 12.
Page 9 of my teaching submission, my lord.
Yes.
Number was said.
Page 9. Page 9 is your submission.
The discharge officer read petition was nowhere either in the read petition nor in
That's
his
all right. Mr. Das, this is okay. Let's go to the case now. Just, can you just give me the paragraphs you want to rely in the first case? State of Bank, State Bank of India. Which paragraphs?
Page 11.
Paragraphs, just indicate the paragraph.
Yes, sir.
Where?
Yes.
Where have you mentioned? Oh,
Page 11,
okay. Sorry.
Along with the citation.
Okay.
Citation, along with the citation, we have mentioned the also, paragraph.
Okay, fine.
Then these are 10, my lord, 9 of the excellent.
Okay, fine. Anything else?
That's all then to 10, my lord, just I am doing, my lord.
Yes,
Page
yes.
11, my lord.
Yes.
The discharges framed was found established by the inquiry officer. Punishment of compulsory retirement from service is imposed upon the service officer, read petitioner. No procedural irregularity in holding the inquiry proceeding. National justice is not violated. Interference with the findings of the disciplinary authorities is unwarranted, my lord. That for that the reference is given only AR 2007 SC 2793, my lord. Where are 15, 16, and 17, my lord.
All right. Which is your star case on the ambit of this out of all these cases? Just take me to that paragraph. Only one case, you can just show me that paragraph.
Yeah. That base 9 also, my lord. Page 7. That if misconduct is proved, the court cannot interfere with the quantum of punishment unless this same is shocking to the
Then they are not even on quantum. They are on perversity. So just one case. You show me which case you want to show. All right. Let us see this 2006-7 then. Scope of judicial review, service matters, departmental proceeding. Which paragraph?
Paragraph 6, 9, 12, and 12, 13, and 19, my lord. Hmm, 2006 or 7.
It is impermissible for the High Court to reappreciate the evidence which had been considered by the inquiry officer, a disciplinary authority, and the appellate authority. The findings of the High Court on facts runs to the teeth of the evidence on record. Para 9. Para 10. The clinching evidence found by the inquiry officer against the charged officer is in the form of so and so. So this I don't think is related. Then para 15, a disciplinary proceeding is not a criminal trial. The standard proof required is that of preponderance of probability and not proof of so and so. There is a very one decision which talks about weighing of evidence will not go into by the writ court. Mr. Are you having that decision? Says, the writ court shall not weigh the evidence. If there is evidence, that's end it. Only in a situation where there is absolutely no evidence, then it's a case of perversity. That is the meaning of perversity. So, but there is one in the context of disciplinary proceeding, there are many cases such on perversity. Why I am saying perversity? Because I am given being given the impression that the only ground urged by the petitioner is perversity. Now, if that be so, this court need not go into the other areas. This court has to confine its finding only on that. So for that, the findings of the inquiry officer is already on record. It's on record. The court has to only satisfy whether there has been some evidence or not. That's it.
Then this 11 my lord, Roman 11 my lord, that honesty and integrity are an inbuilt requirement. Misconduct has to be dealt with an iron hand. That is 2003, 3 CC my lord.
Where are you? Oh, from that list you are reading.
Page 11 my lord.
Yes, yes, got it, got it. Okay.
These are page 12 my lord.
Yes.
Roman 14 my lord.
Yes.
That it is not open to the High Court to re-appreciate the evidence in exercise of its.
Let us see this. Let us see this. Which page will I get this 2015?
12 and 14 my lord.
Let us see this.
AR 2015 SC 545. 545.
Page? This is the SSC citation, yeah? Yes, it's at page 61. Paragraph is, you've not given the paragraph. Okay. Court cannot venture into reappreciation of evidence or interfere with conclusion in inquiry proceeding if the same are conducted in accordance with law or go into reliability, adequacy of evidence. Or interference if there is some legal evidence on which findings are based or correct errors of facts, however grave it may be, or go into the proportionality of punishment unless it shocks considerably court. Okay.
Before that, this Roman 13 my lord, page 12 my lord.
Yes.
That the order of compulsory retirement is neither a punishment nor a stigma. The court may interfere if it is satisfied that the order is passed mala fide. It is based on no evidence. It is arbitrary, my lord. There is a reference, my lord, to 1992 to SCC, my lord. 299.
Okay. Yes. Reply at you probably will give a short reply, isn't it? At 2.
My learned friends, actually, I am permitted to mention one paragraph of our APVT opposition, my lord, page 126, my lord.
Page?
Page 126.
126, yes.
From middle part, my lord. I am mentioning it.
Yes.
From middle part, my lord.
Mhm.
PGCL, Power Grid Corporation of India Limited, being a Maharatna Central Public Sector Enterprise under the Ministry of Power, Government of India, is an integral part of the nation building process. And the nation looks forward to PGCIL for its strong values, ethical practices, and project management as a driving force of the nation's national economy. PGCIL, being a public entity, deals with public money, and the manipulative action of the petitioner was a deliberate action towards loss to the national exchequer. The gross misconduct done by the employee through the manipulation of the system and process has thus been rightly penalized with a compulsory retirement after complying with all the necessary inquiries and providing ample opportunity to the employee to defend his action.
Yes.
About this action, integrity matter, for that actually I am referring this paragraph, my lord. But you are holding the position of that DGM, my lord, that given time, my lord.
Yes, Mr. Cholia.
Yes.
Well, at the outset, I'll point out one thing. My London friend was telling that I have not taken steps, taken any grounds regarding purpose finding. My Lordship might remember, I filed an additional affidavit on 1/8/25, 2025, at that your Lordship will find at 269 paper book. There I have given details of the regarding the charges and how it is without any evidence. At page 270.
Yes.
Third one, your Lordship might remember, is regarding my allegation that I allowed my wife to contract in a corporation by way of giving my JCBs, giving her JCBs for contract work to the company. But the evidence they have produced shows that one Sujya Saitya, their witness, he got this JCBs engaged in the work of the corporation, and the money was paid to the petitioner's wife as the hiring charges. So evidence that is before the inquiry officer or in the court or during the proceedings, departmental proceedings, does not show that she was doing contract of her own and I allowed it. That way, I was trying to show that that finding is purpose. Then against two also, then in affidavit at 270, at paragraph 3, that with regard to charge number 2 relating to the non-disclosure of purchase of the excavators by the wife in the annual report of the year 2015 and 2017, the deponent states that the vehicles were purchased by the wife and his brother and her brother through bank loan, and the petitioner has not furnished any money towards the said purchase. Non-disclosure of the fact of the purchase in the annual report could not be treated as an offense in or causing a major penalty in view of the office circular that I have referred to, office circular I referred to at page 1, annexure 1 that your Lordship will find at page. Reply. At page 265, annexure A. Guidelines to be followed in handling limitation of acquisition of report resorted by public servant. There at 266, what should be the punishments for non-disclosure? It is clearly stated in this circular. So it amply proves that there was no proper adjudication of that charge against me. Since this says, Milan, if not related to assets, because there is no indication that I put assets there or money was put there, or it is disproportionate to my income, then only they can issue proceedings. Otherwise, it can be only warning or censure. It will not amount to misconduct.
All right.
Then
yes.
Then I go to paragraph 3. at page 270. That I have stated. Then regarding the two bills, where it is alleged that I paid more money, then it has to be recovered. That I have given. How there is no evidence in that respect also. Wherein it is alleged that deponent, while making payment for site cutting and site leveling, has released an excess amount of 2,324,222 to the concerned contractor, thereby has made excess payment towards R4. It is alleged that I have not verified the bills I have given without verifying it. I have given for cutting and leveling also. It may be mentioned that the said amount have been recovered because there is no allegation that I have made money or a company has lost something.
Yes.
Because that was recovered from the agency. As in the evidence statement, it is reported that I have given in repetition also. The further says that relating to the cutting of art and labeling of the site, the respondent themselves have issued a circular.
Yes.
On 26/3/2018. That circular was given on 26/3/2018 by the department.
Mr. Cholia, the problem is that these are all very factual issues. How do you?
No.
How can a writ
There
court?
is no evidence.
I understand, but you
There
see,
there was no evidence.
ultimately, what you are calling for a writ court to do is to balance these factual aspects and find out whether these are sufficient evidence or not. It is your contention that this cannot be treated as evidence. In other words, in short, you want the sufficiency of the evidence to be judged. You see, in other words, I'm saying.
No.
Whether that can be done by the writ court.
Does not prove that I have done it.
That's right.
If you take this into consideration.
But what does that mean, Mr. Cholia? It means
because
that
there was no evidence
Mr. Cholia,
on a charge.
Mr. Cholia,
Yes.
What you're trying to say, in other words, is asking this court to reappreciate and appreciate the evidence that were before the inquiry officer.
No.
That is exactly what you're asking, isn't it, Mr. Cholia?
That your lordship
If
can
this
do.
court has to now go and see this evidence. I could have appreciated your arguments in a situation where there was no evidence at all. Here the evidence is there. But whether these evidence are sufficient to bring home the charge of the charged officer is the question.
There are 17.
For that, I'll copy some. I'll just read the paragraph. This is paragraph 17.
Yes.
Yes,
2022-17 scale 577.
Yes. Scale. CISF and others.
Yes, you may read para 7.
We have reservations regarding the reasoning given in paragraph 10 of the impugned judgment, as it fails to take notice and properly apply the law of judicial review. Judicial review is not akin to adjudication of the cases on merits and adequacy or inadequacy of evidence, unless the court finds that the findings recorded are based on no evidence. Based on no evidence.
Perverse or are legally untenable in the sense that it fails to pass the muster of the Wednesbury principles.
Yes.
I am also saying the same thing. There is no quarrel to that proposition. There has to be no evidence. The problem I'm finding is that there are evidence. You cannot say this is a matter where there are absolute no evidence. Your relation with your wife, the fact that her JCBs are used, the fact that initially these things were not disclosed in your source of income, These things are there. The fact that there are vigilance report, these are evidence after all. The vigilance report, Mr. Choli, I appreciate what is falling from this court.
Yes, yes.
I have not made my mind, but I am saying, how do I appreciate your argument in the context of these facts, right? Because there are two vigilance reports. These are evidence ultimately. Those vigilance reports have indicated discrepancies and irregularities in that project. Then those two bills, they have come by way of evidence. Now, this court cannot ignore these evidence and say, no, no, these are not evidence. These are bad evidence, these are good evidence. Can this court do that? I could have understood if nothing was there. And only because you did not disclose it in the source of, in that assets disclosure, you have been given this. Then I would have appreciated your argument because that circular says warning. But here, that is not the sole allegation. That is one of the allegation.
No,
The,
in Alatu also I'm showing regarding number 3.
Yes.
That was number 2. Number 3, there regarding 2 bills.
Yes.
There that I want to. No, like my problem. At page 260.
Page.
Page 260, second paragraph.
Page 260.
260.
Yes.
There was some confusion relating to measurement of the area of work, and therefore there was excess payment of that particular amount. The said amount was, however, been deducted. Next running bill from the running bill of the contractor, and thus it cannot be said that there was an excess payment giving undue financial benefit to the contractor. The deponent further states, this is important, that the respondents took out the circular dated 28/3/2018, wherein it was specifically mentioned that the method of measurement and regarding payment of ongoing work relating to artwork. As such, since there was some
I think some error or something.
error, some error, I'm sorry, there is a mistake. In preparation of bills for cutting and filling, the deponent cannot be penalized for the same, and more so when the excess amount has been deducted from the bills of the contractor. In view of the above, the charge against that I have circular I have given, that you also will find at page 262.
These are factual things.
Had these facts been given, because the allegation that has been made, Milord, I made financial loss. That is nowhere there.
That allegation is consequent of the charges that has been leveled against you because of these because of the illegalities that have been committed in clearing the bills. Indirectly, it will mean what? That some loss have been obviously caused to the national exchequer. This is their case right from the beginning. So what power to disclose? They did not have to disclose that because of this loss has been. It's ultimately anyway. Anything more?
Their circular is there, Milord, where it is clarified that you cannot charge for both cutting and filling, because that confusion that was there earlier. Otherwise, why this circular will be there? And after this circular only, the money was deducted from the contractor's bill. That factor your lordship has to see.
Okay.
Then on the fourth charge also, there is practically no evidence. They themselves have said it will charge की तरह से.
দেখাত মাতি দিব আছে
That fact I have stated regarding number 3, that your lordship will find at page 31 of the paper book. Where is this clear, sir?
yes
Regarding 10.4.18, they have initiated a proposal for recovery of the excess amount. But this circular was made before that. In 3, that was made, circular was given, and recovery was done thereafter only. So after the circular only, that was done. And for Article 4, regarding clubbing of bills, that is funny again. At page 32, I read. Indication in this article is that I have not clubbed 2 bills of 37 lakhs and 16 lakhs. There were 2 bills which I passed, which the petitioner passed on the same day. And had these 2 bills been clubbed, it would have been more than 50, and it will be beyond my power of approval and payment. Because above 50, it goes to the GM. Then it is, how can it be justifiable? I'll show. SK who can processed 2 second and third RA bill on the same paragraph, same page 32, on the same day, and Iman respectively to authorize the bills for payment within his financial power as per Power Grid DOP. If both these 2 bills happen to be prepared in a single RA bill, the total amount would have been 54. As per clause 24 of DOP 1, chief manager has power to authorize payment of the RA bills up to 50 lakh only. The DGM is empowered to pass the
so
bill.
what are you trying to say here?
They say,
no, forget what they say. What is your submission in this regard?
no, what is the language they are putting?
No, I've understood. Now, I want to know from you, what is the submission in this regard that you're trying to bring home? What is your submission?
Submission is that I am not required to club the bills or to pay separately, because this comes to the officer for payment. And these 2 bills were processed. I have given.
Just indicate in short what, because you see, I'm just trying to understand the point that you want to bring home. We will go to those pages later if need be, because you have already, I have seen that these things you have already argued earlier. They've been already noted. So just give me that point. What is that exactly? You are saying that you are not required to club it.
Yes, I'm not required to club it. Office is to
under the terms
and I have stated these 2 bills were processed on different dates. At page 271. From the evidence adduced by the department, they themselves had put this evidence. It is clear that bill number 1 was raised on 31/5/17 and forwarded to the finance department on 29/6/17, while the bill number 2 was raised on 27/6/17. One was in May, one was in July.
So the question of clubbing it will not come.
So for this charge also, there is no evidence.
Okay, fine. Very well.
So and my learned friend was reading in the
You all in the back are the law interns or law students? Yes, you both. Law interns. From 3 of you are there. From which college? Sorry? Nareem. I hope you all are following what is going on.
No, no. You also have to use code. And lastly, regarding my learner train submission that he made from reading at page 126 of his affidavit.
Yes.
That PGCL being a entity deals with public money and manipulative actions of the petitioner was a deliberate action towards loss to the national exchequer. No money was lost in any of these. Company has not lost anything because there was no contract in respect of one. Contractor got the bill and paid it to my wife.
Okay.
In the last also, excess amount was withdrawn. That too on the basis of the circular issued by them. So no loss of money was there. These are my submissions.
Very well. Mr. Das, there's no reply to reply given, but before I come to that, yes, you all are also law interns. The girls in the back. Yes, get up. Law students or law interns? Law students. From which college? Yes, speak up. Come in the front. From where? You have come from Meghalaya. Very good. I hope you are following what is happening. Which year? First year? Both of you? You're from Bangalore. Which year? Third year. All the best to both of you. Please be seated. Yes.
Now, only my lord, actually, I'm referring to the paragraph number 3 of the additional affidavit, my lord has referred, my lord. That is, this paragraph is totally contrary to the amendments made in the original writ petition in paragraph number 3, my lord. That paragraph 3, that with regard to clause charge number 2 relating to non-disclosure of the purchase of the excavator JCB by the Y in the annual property report of the year 2015 and 17, the difference states that vehicles were purchased by the wife and her brother through bank loan, and the petitioner has not furnished any money towards the said purchase. This is totally contrary to the amendments made in paragraph number 3 of the original writ petition, that he has himself, that he has lent some money.
Anyway, that is not relevant to a lot because these are ultimately reapplication evidence. But you, Mr. Das, just tell me one thing. This clubbing issue, they are saying that it can because of the year were different. What do you want to say to that?
For that actually, my lord, our April page 125, my lord, paragraph 17, my lord. 125, my lord. Paragraph 17.
125.
125.
Yes.
That with regard to the state amendments made in paragraph number 20 of the writ petition, the defendant states that as against the charge number 4 labeled against the petitioner, the plea taken by the petitioner was not sustainable in view of the fact that both the bills were signed by Sri Sangma, junior engineer, on the same day and also passed by the petitioner on the same day. The amount of rupees are the amount of these two bills exceed the delicate financial powers of the petitioner, and instead of passing the aforesaid two bills by himself, he ought to have send the bills to the next higher authority for doing the needful in the matter of.
I have not understood. Here you are saying that was not sustainable You are saying it was on the same day.
Same day.
But somewhere from the evidence of your evidence, it has come out the dates are two different dates.
But
This is what Mr. Chalia is pointing out.
But
If there are different dates, then these restrictions don't come.
no, the bills were signed by Sri Sangma on the same day, my lord.
How do you show that where in the evidence it has come? Because if I have understood Mr. Chalia correctly, he's saying that from your evidence, two dates emerges. One in respect of one bill, another date in respect of the other bill. So that means they are not processed on the same day.
Right.
You cannot say that these bills have been passed on the same day because the dates are different. And if the dates are different, then that capping will not be applicable, because that capping would be applicable for bills passed on in one particular day. Correct, Mr. Chalia? You have said that.
Yes, I'm on that. I've given evidence. They have evidence also.
Where is that evidence?
That will be at page 201, my lord. Of the inquiry report.
Yes, 211.
201, my lord.
Yes, what do you have to say to that?
As has been narrated, this article 4, my lord, as has been narrated under the conclusions finding for.
Here you are saying they have been signed by Sangma on 29/6/17.
On the same day, my lord. It was signed by this.
Okay, fine. And Mr. Chalia, which part were you relying?
Yes, I'm hearing. Evidence के लिए तो अपडेट करो से evidence के लिए दिया evidence at 271 bottom
270. Yes. Yes, here only.
Yes.
Paid two separate bills on one day, that is on so and so. And alleged as that if two bills are combined together, it will exceed. The DOP only stated the deponent is authorized to make payment of so and so and so and so. The bill 1 was raised on 31 and forwarded to Finance Department on 29/6/17, while the bill number 2 was raised on so and so and forwarded to on so and so. Cannot be said to have processed the bills on the same day and authorized the bill for payment with his financial powers. Now, what is the requirement? Making the bill or what? When did Sangma sign both the bills? Processing is one thing, but when was it signed? Where these bills have been exhibited as Exhibit D19-1 and Exhibit D19-2. What is the date in the bill of the signature?
Sangma signed on 29/6/2017, my lord.
Both.
Both, my lord.
So that's it then. All right.
Bills are there at 80.
Bills is okay. The check, the bill, sorry. Bill number 3A and bill number 2. Bill number 2. All right. Anything more?
In the written submission, I've given the bills.
Okay.
That your lot will find. Bills also. Based on different dates.
The date up in the bills, the date is different there, but in the signature, you see, both the signature signed on the same day. They are saying signed on the same day. They have not said something else. Anyway, arguments have been closed. Now let me dictate. Court counsels can take your seats. Sorry?
There is a bioweapon clarification this was issued, my lord. Circular, my lord.
Which circular, Mr. Da?
Page 267, my lord.
What does that say?
Method of measurement and release of payment.
Okay, that's all right.
That's right.
Heard Mr. D.P. Chalia, learned senior counsel, appearing for the Petitioner, assisted by Miss M. Roy, learned counsel for the petitioner, and Mr. N.C. Das, learned senior counsel, assisted by Mr. A. Das and Mr. A. Srivastav.
A Pandey, Your Honor.
And put A. Pandey as well. Huh?
For two,
For
three, and
the
four.
for the respondent numbers,
2, 3, and 4, Your Honor.
all of you.
Yes.
For the respondent numbers 2, 3, and 4. What about 1? Who's 1?
Union of India.
Anyone there from the union? No one, nobody is there. You can ask someone, one of the CGC,
Yes, I'll put it.
if he's here, because this dictation will take time. If someone comes, I can put the name. Because they will be just a formal party, I suppose. The writ petitioner put K. Costa, Costa Gogoi, Leonard CGC, for the respondent number 1. Yes. The writ petitioner puts to challenge in the instant petition under Article 226 of the Constitution of India his compulsory retirement from service, the order of compulsory retirement from service by the order dated 29/10/2020, primarily on the ground that the disciplinary authorities primarily on the ground that the findings of the inquiry officer is perverse, is totally perverse. Inasmuch as there was no evidence of bringing home the charges leveled against the petitioner. Stop. The brief facts of the case is that the writ petitioner, pursuant to his selection and appointment, joined Power Grid Corporation of India Limited in June 2010, and during the period from November 2016 to February 2016, he was posted at Phulbari, Garo Hills as chief manager. Stop. While he was posted therein, he was looking after and overseeing the construction work of Phulbari substation under the Northeastern Region Power System Implementations Project for strengthening interstate transmission as well as distribution system to the state of Assam, Meghalaya, Manipur, Mizoram, Nagaland, and Tripura. Upon an allegation that during such course of time, while the petitioner was posted therein, while executing and implementing the projects under the aforesaid scheme, he had committed serious illegalities, failed to maintain absolute integrity, and also acted in a manner which is unbecoming of a public servant, misused his official position, and also acted in a manner prejudicial to the interest of Power Grid, the chairman and managing director of Power Grid, being the disciplinary authority, decided to initiate disciplinary proceedings against the petitioner. Accordingly, notice was issued to the petitioner along with articles of charges, statement of imputation of misconduct, list of documents, and the list of witnesses. The article of charges framed against the writ petitioner reads as under, quote unquote, Article 1, Article 2, Article 3, Article 4. A written submission of it. Paragraph 3 does. Upon receipt of the aforesaid notice, the writ petitioner, by his letter dated 6/5/19, submitted his reply to the articles of charges. However, the disciplinary authority, upon being not satisfied with the reply so made, decided to hold inquiry against the writ petitioner and accordingly appointed an inquiry officer on 2/9/2019 to inquire against the charges leveled against the writ petitioner. During the inquiry, 6 witnesses on behalf of the management were examined and various documents were exhibited in support, and the delinquent stroke charged officer cross-examined them and had also adduced 3 witnesses on his behalf. After completion of the inquiry officer submitted its report on 28/2/2020, wherein he held all the 4 charges framed against the delinquent writ petitioner fully established and proved. Thereafter, a copy of the inquiry report was furnished to the writ petitioner, which he duly represented by his letter dated 16/9/2020. Thereafter, the disciplinary authority, on and after carefully going through the materials on record, including the charge sheet, written statements, thereafter, the disciplinary authority, upon being not satisfied with the representation, finally passed the impugned order dated 29/10/2020, whereby the penalty of compulsory retirement from service was imposed upon the delinquent writ petitioner. Against the aforesaid penalty, though an appeal was preferred before the appellate authority of the Power Grid on 27/11/2020, however, the same was rejected by the appellate authority on 27/11/2020. Pursuant to the rejection of the appeal, a review was also filed before the reviewing authority, which was also rejected by the reviewing authority. Situated thus, the present writ petition has been filed. Mr. D.P. Chalia, Learned Senior Counsel, submits that the impugned findings of the inquiry officer as well as the disciplinary authority is totally perverse, inasmuch as there is no evidence whatsoever in support of the allegations brought against the writ petitioner. He further submits that the JCBs of the petitioner's wife was utilized by the contractor engaged by the power grid and not directly by the wife of the petitioner, and the payments were made who Surja Saikia, who Surja Saikai.
They were contractor.
And the contractor had also made payments to the wife of the petitioner for utilization of the same.
They were
He further submits that he further submits that the petitioner could not have been compulsorily retired from service for not disclosing the purchase of JCBs in his annual property return, inasmuch as the same cannot be treated as an offense for major penalty in view of the office circular, wherein it is categorically mentioned that in case of allegation of source of allegation of utilization of any amount, such cases should be let off with warning or censure. তাতে সাইডত লিখি থবচোন page 265 annexure I অফিচাৰ এইটো এডিট কৰি দিম। He further submits that though the petitioner has been alleged to have not measured the cutting volume and felling of earth properly, however, as per provision, the payment for cutting volume is payable only, but payment for both cutting and filling has to be made and thereby an amount of rupees 2324220 was made in excess to the party. However, after inquiry, the excess amount having been already recovered from the contractor, no loss whatsoever has occurred to the corporation. Correct? This is what you are saying.
Yes.
He further submits that the allegation of giving undue favor to the contractor while paying the authorized payment for cutting and filling of the earthwork is also questionable in view of the instructions issued by the circular dated 26/3/2018, issued by the Power Grid Corporation on the subject of matter of measurement and released of payment for ongoing work. In the aforesaid circular, it is stipulated that the process of measuring and marketing of payment. I think there is some English.
Making of payment.
There are a lot of spelling errors and grammar errors in your submissions. Your office has to be more careful, Mr. Chalia. কি লিখিলা? And making of payment for the work done are not to be followed, and the procedure for release of payment forwarded should cover the items He further submits that the two bills petitioner cannot be held liable for cutting payment for both cutting filling of earth. He accordingly submits that there was ambiguity in the process of making payment for cutting of earth and filling at site. Here the language spelling is side. It's site, I think.
Yes.
Full of errors, Mr. Chalia. The problem is all this error is now going to go into my order. We depend on the submissions. Submissions are called for to facilitate us to dictate judgments in the court, because the need of the hour is to clear your disposals. Cutting of earth and filling at site, site. And therefore the petitioner could not have been made a scapegoat for making excess payment. He further submits that the petitioner that both the bills were prepared on different dates and the petitioner is not the person who prepared the bills. Hence, the question of excessive payment, that issue is related to excessive payment. Therefore, there cannot. Therefore, it does not exceed rupees 50 lakhs in terms of Rule 24 of DOP for making payment of two bills. Okay. In support of his submissions, he relies upon the decision of the apex court in the case of CISF and others versus Santosh Kumar Pandey, reported in 2022, volume 17, scale 577. Per contra, Mr. Das, Leonard Senior Counsel for the respondent, submits that it is not the pleaded case of the writ petitioner that the findings of the inquiry officer is perverse or is not based on evidence on record. He further submits that the only ground pleaded in the writ petition, particularly in paragraph 23 of the writ petition, is as regards the proportionality of the quantum of punishment. He further submits that the inquiry proceedings held against the petitioner was in respect of 4 charges, which, having been found proved on the basis of evidence on record, both oral and documentary, the disciplinary authority, the findings of the inquiry officer and the penalty issued by the disciplinary authority cannot be faulted with. Stop. He further submits that the writ petitioner, having failed to maintain absolute integrity by acting in a manner which is unbecoming of a public servant and misusing his official position, has prejudiced the interest of the corporation, stop. He further submits that the writ court does not have the power of judicial review under Article 226 of the Constitution of India, and it cannot act as an appellate authority. In support of the aforesaid submission, he relies upon the decision of the apex court in the case of so-and-so versus so-and-so, reported in 2006, volume 7, SSC 212. He further submits that in so-and-so, reported in 2008, volume 7, SSC 580, the apex court have clearly held that if the misconduct is proved, the court cannot interfere with the quantum of punishment unless the same is shocking to the conscience of the court. He further submits that he further relies upon the decision of the apex court in AIR 2007 SC 2793 to contend that in the event the charges framed was found established by the inquiry officer, and when no procedural irregularity or natural justice having been proved to have been contravened, the court shall not interfere with the findings of the disciplinary authority. By relying on the decision of the apex court in the case of so-and-so versus so-and-so, reported in 2003, volume 3, SSC 605, he submits that the apex court has held that honesty and integrity are inbuilt requirement and misconduct has to be dealt with iron hand. Mr. Das, I'm not recording your submissions on quantum. I have given one because he is not argued on quantum. He may have pleaded quantum, but that's not the argued case before this court. And rightly so. In support of his submission that the writ court shall not reappreciate the evidence in exercise of its writ jurisdiction under Article 226 of the Constitution of India, he further relies upon the decision of the apex court rendered in the case of so-and-so versus so-and-so reported in AI 2015 Supreme Court 545. The issue which falls for determination in the instant writ proceeding is as regards the as whether the findings of the inquiry officer is based on evidence or not. Undoubtedly, while reviewing judicially the inquiry proceedings initiated by the inquiry officer in relation to a disciplinary proceeding is limited. This court does not sit as an appellate court. Certainly, if there is no evidence in support of the allegation leveled in the charge sheet, the findings of the inquiry report officer would be termed as perverse and an interference thereof is warranted. However, if there is evidence whether the same is adequate or not to bring home the charges leveled against the delinquent is not going to be undertaken by this court while exercising extraordinary writ jurisdiction. In short, the sufficiency of the evidence cannot be gone into. Keeping the aforesaid limitation in mind, let me now turn to the findings of the inquiry report itself. Perusal of the inquiry report abundantly clarifies that the same has that opportunities have been fully given to the delinquent writ petitioner in the inquiry proceedings. Not only the delinquent writ petitioner has cross-examined the 6 prosecution witnesses, but has also brought his own witnesses, numbering 3 in number. It is further apparent that based on the evidences as well as both oral as well as documentary evidence, the inquiry officer has come to the conclusion that the 4 charges have been proved against the petitioner. It is further apparent that the charges are serious and the same having been proved clearly indicates that the petitioner, by misusing and abusing his position, has committed misconduct. In relation to article of charge 1, it has clearly come out that while he was in charge of the subject project under the scheme, he had his wife was doing business and renting her excavator to the corporation. And accordingly received rupees 237,000 in her bank account from the contractor against hiring charge of earth excavator owned by her. It is clearly established that similarly in relation to the other articles of charges also, there are clear evidence showing that there has been irregularities in the bill payment, and despite the bills having been signed by the delinquent writ petitioner on the same day, i.e. 20. Where is that date? (29/6). No?
Yes.
29/6/17. it exceeded the the limit of above 50 lakhs, right?
Financial power.
Which is contrary to his financial powers. Be that as it may, it is apparent that there were evidences in front, that there were evidences apparent, no, be that as it may, there were evidences available on record which clearly proves the charges brought against the petitioner. The adequacy and sufficiency of the aforesaid evidence cannot be gone into by this court at this stage. Since there was evidence, therefore, it cannot be said that the findings of the inquiry officer was perverse. Perversity means lexicon or মই দি দিম এইটো তোমাক পিছত ভৰাই দিম তাতে ব্ৰেকেটত lexicon টো লিখি থৈ দিবা having held so তাৰ আগত যাবা the arguments of Mr. Chalia to the effect that by relying on circulars to show that there was no irregularities as far as the making of the bill and what was that you were mentioning about the measurement, no?
Measurement, yes. Cutting and filling.
As regards cutting and
Filling.
pleading.
Filling.
Filling. Cutting and filling. These are matters on merit which this court, while exercising writ jurisdiction, shall not go into it. In any event, these are already been proved. It has already come out through evidence, and the inquiry officer has already taken note of the same. That being so, I do not find any merit in the instant writ petition. Accordingly, the writ petition stands dismissed. No cost. Sorry, Mr. Chalia. I'm going to edit the final judgment. So by tomorrow, you will get a copy of it. Huh? There'll be some editing. Yes.
Public.
Yes.
Into a maybe lordship.
Yes.
Maybe lordship. But petition is the lordship temporarily engaged lordship in KGVB Vidyalaya lordship since 2008 lordship as head cook and assistant cook lordship. Their continuing service lordship.
What is this matter, Mr. Bora?
Since the board has decided that male cook and male cook cannot be engaged in a girl KBG Vidyalaya only for girls. Ultimately, the imperial order was issued that they should be, since they are in contract, 11-month contract, they are not continuing.
They will not?
They are not continuing.
They have where is that impugned order?
Next up 15 lordship.
37?
37 lordship.
Yes. The last annexure. Yes. Yes, please.
With reference to the subject cited above, it is to inform you that during the project approval board meeting for consideration of so 15/7 Government of India, and there is also note that Government of India suggested for a restriction in any residential male staff in a KGBV campus for ensuring safety and security of the girl child in KGBV. It is therefore decided not to keep any male hidden staff like cook, assistant cook in KBB. In view of the above, you are hereby directed not to extend any further deed of agreement with any male cook.
What is wrong in this order?
Lordship.
What is wrong in this order?
Lordship, there is already standing circular, Lordship. On the basis of such circular, Lordship, we are duly provide our service, Lordship. Lordship, kindly come to the case number 18, Lordship, Annexure 1, Lordship.
This is regarding non-execution of further deed of agreement with male cook and assistant cook working in Kasturba Gandhi Balika Vidyalaya, right?
Yes,
So the only restriction is that for in future you are not to engage anymore male cook and assistant cook, correct?
Yes, Lordship.
So it's
They are contractual even period is over.
Yes.
Thereafter their
ultimately who's going to make payments? Who makes the payment? So they don't want you to engage. So what is wrong in it?
Lordship, there is already standing circular. On the basis of the said circular, we are working, Lordship, in the said premises, Lordship. There is no any allegation against us, Lordship. Lordship, kindly perish, Lordship. Annexure 1, Lordship. Page number 18, Lordship.
Annexure?
Annexure 1, page number 18, Lordship.
This is the matter you were seeking for time in the morning. Somebody else was supposed to. Anyway, when do you want it? We'll have it on another date. Now, anyway, it will not be much time. When do you want it?
Next week, Lordship.
As prayed for by Mr. M. Hussain,
Yes, sir.
learned counsel appearing for the petitioner and as prayed for by so and so on the ground that the conducting counsel is out of station, you said, right?
Yes, sir.
Relist on such and such date. Silo sir to date to besi unkala disani calendar to silo ba. Yes, next. Next week on board kita matter speaker sir Rupa. Just be mindful when you're fixing it.
Item 22.
Dismissal from service.
No, not like that, my lord. Petitioner was engaged in Assam tea plantation and industrial security force initially. Since 30/11/1993 to 12/12/2003, he was in service. I have annexed the certificate, service certificate, and also the command certificates. Subsequently, what happened, my lord? One FIR was filed on 30/6/2001, and after that, that was succeeded, and Honorable Additional Session Judge Vishwanath Sarali honorably acquitted me and other accused persons on 30/9/2016. That was subsequently, I have obtained a copy, and thereafter I filed one representation. What happened, my lord? That initial ATPSF was subsequently by government notification, two battalions were formed: Assam Industrial Security Force and Assam Special Reserve Forces. And the similarly situated candidates in pursuance of the High Court orders on different dates were absorbed. So I will be given that same benefit, my lord. And also I have annexed all the documents. Separate document.
As far as representation is concerned, Lordship, that representation is not received by the respondent authority, Lordship.
So they are saying they have not received your representation.
It is clearly stated in
That, my
paragraph
lord,
13, Lordship.
I will come.
Where is the representation?
Lordship, it is annexure 10, page 53. What happened, my lord? While I was in service, the office was at Beltula. Subsequently, that was shifted. That was, but
You want reinstatement.
yes, my lord.
Your prayer is for
I
reinstatement.
was never dismissed. Kindly come to the order, Lordship.
No, I'm saying your prayer. Your prayer at page 53 is your document.
Yes, my lord.
So the prayer is for reinstatement.
Lordship, the discontinue order, Lordship, issued on.
Huh?
He has submitted like that, Lordship.
What do you mean by he has submitted like that, Mr. Counsel? This is your document. Page 53 is not the court file. It is your document in the court file. It's your writ petition. It's your representation. You have signed it.
What
Lordship,
happened?
discontinue
He is
order
not
2003, Lordship.
highly
Now,
qualified person,
in
Lordship.
2017, he has not challenged that order, Lordship. On 2003, Lordship, that order was.
All right, some other day.
Lordship.
Obliged, obliged.
29.
Need physiology.
Who is denying you the pension?
Matter may be adjourned for the day, Lordship. Mr. R. Mudumdar has some personal difficulty. Any date,
Okay.
Lordship, next week?
Mr. Gogoi, she wants an adjournment. Okay. As prayed for by Mr. R. Majumdar, Learned Counsel appearing for the petitioner, which is not opposed by Mr. K. Gogoi, Learned DYSGI, relist on such and such dates.